Good morning, everyone. Welcome to the first day of our, what month is this? January call. Honored to be here with two of my colleagues, Judges Mariani and Trebilcock. I can assure you, contrary to what you read or write to one another in your various message boards, we have read the submissions that you have presented to us. We're very familiar with your cases, and I hate to break it to you, but the purpose of oral argument is not for you. It's for us to assist us in the drafting of an opinion on your matter. So please pay close attention to the questions that we ask, and hopefully together we can come up with something that'll, make you very happy or very angry. And we're either going to be a bunch of really smart men today or a bunch of idiots. Either way, we'll carry on. That brings us to the first case on our call, case number 370180, REL Financial versus Joe Barbett. Both sides are endorsed for oral argument. Good morning, counsel.
Morning, Your Honors. Josephine DiLorenzo on behalf of defendants. We're asking that you reverse the trial court's order because this dispute and over the note and the guarantee is subject to arbitration. The operating agreement includes an arbitration clause with the broadest possible language, and the operating agreement expressly contemplates the loan that's at issue here.
Did REL sign the operating agreement, the whole operating agreement, or just part of it?
Well, REL Financial, the plaintiff in this case, did not sign the operating agreement.
So would you not agree that arbitration is a matter of contract?
It is a matter of contract.
Not a matter of right. So where's the contract that's REL signed that says that they agreed to arbitrate?
Well, I would still go back to the operating agreement.
But if they didn't sign the operating agreement, why are we going back to it?
Well, I would start with section 4.1 of the operating agreement because the parties to that operating agreement agreed that a portion of Barbatt's capital contribution would be a loan to Barbatt's River House from RE or an affiliate of RE. RE is defined in the first paragraph of that operating agreement as short for River House Jr., which is the member. So in other words, plaintiff REL Financial is actually referenced in 4.1 of the operating agreement as an affiliate of RE. We didn't bring this out in our brief, but there is actually a definition of affiliates in the operating agreement. And it defines an affiliate as an entity that is owned or controlled by another entity. And that full definition is in our appendix in the operating agreement at 0609A. So.
But you didn't have the lender entity. The lender entity still isn't identified, right? Presumably because we still don't know necessarily, or for whatever reason, the agreement didn't want to name the lender at that point.
Correct. I guess it's giving RE, as in River House Jr., the choice whether they're going to make the loan or their affiliate's going to make the loan. And RE Leibovitz, the individual, and Joe Barbatt, the individual, no one other than those two controlled or owned more than 10% of any entities that are involved here. So that's why we refer to the doctrine of imputed knowledge, because plaintiff here can't say that it lacked knowledge of the arbitration provision when
How does knowledge get you to, let's say I agree with you. Let's say, okay, they knew about the arbitration provision, but knowing about it doesn't mean you're bound by it. So, it seems like we're still a couple steps removed from being bound to arbitrate just because we impute knowledge of this agreement between entities that don't comprise specifically the one that actually was on the note.
Well, I guess they didn't expressly agree to it because they didn't sign the agreement, but still, they did still know about it and they still made the loan. I would just also point out that this operating agreement does expressly recognize that the parties to the agreement may involve their affiliates. So if you look at Article 2, that deals with the loan for the property as a whole, and it allows the company to enter contracts with affiliates under certain parameters. Affiliates are also referenced in Article 4, which is what we're talking about because that's the capital contribution loan provision. But there's also Section 4.4, which addresses loans to the company, and it says that River House may obtain a loan from a member or its affiliate. So I guess the parties are sort of representing that their affiliates may be involved in this, and there's nothing anywhere that says that those affiliates won't be bound by the arbitration clause.
Well, I mean, there's nothing that says, I would be either, but it's it seems like you contemplated involvement of affiliates, but yet you could have had those affiliates sign the agreement if you wanted them to be bound by it.
Or it says in there, it references entering into a loan agreement, right? And so if you wanted it to be subject to arbitration, you would have included an arbitration provision. Hopefully, in that loan arbitration. Is that the proper interpretation?
And
By excluding it, doesn't it? It would be applied to statutory or the contractual interpretations by excluding it in the loan agreement when it expressly wasn't to be included.
are you talking about the note? Are you talking about the
No, yeah.
the note? So the note does, well, it does incorporate the capital contribution provisions. And I guess I would just point out, I know the trial court and plaintiff are arguing, so that specific article, Article 4, doesn't mention arbitration. I think is that your point. I would just point out that the capital contribution loan is mentioned elsewhere in the document. Again, I don't believe this was in our brief, but in Section 8.3 of the operating agreement, the parties agreed that House Living, which was another Barbat entity, was going to be the property manager, and it would be paid 5% of the gross monthly rent collections. And the accrual of that fee and the due date on the note are tied together because 8.3 also says the fee says that the fee shall be accrued until the interest and principal and the capital contribution loan is paid in full, and thereafter the fee shall belong to House Living in accordance with this agreement. So to me, that says that the note, if it's anywhere in the document referring to the capital contribution loan, it's the operating agreement as a whole. But even let's say you were indicating, perhaps you don't agree, that still this dispute here is.
There's no perhaps.
Okay, well then, I would say still the case should have been dismissed in favor of the arbitration under MCR 2.116C6 and the first filed rule, because that rule doesn't require that all the parties and all the issues be identical.
Counsel, can I just make sure I'm understanding the flow chart here. So because I know you have your arbitration argument, and then you have the first filed argument and the first breach argument. So let's say I don't agree with you on the arbitration piece. Is that dispositive of those other two claims, or do those require their own analysis? And if so, walk me through that.
So basically the case law that we cited in our brief says that collateral or res judicata, so claim and issue preclusion issues, principles would apply here. And I don't think you can disagree that the arbitration, because we attached the whole giant complaint, is going to be preclusive of what's going on here. The facts of the arbitration complaint go through the whole history of this property, which starts with this loan that's at issue. It goes through their dispute. They had disputes over construction companies, liens on the property, breach of the capital call, breach of the operating agreement, and that eventually ended up in foreclosure. And
Did you have breach of those other things? And also, I mean, I guess I understand why we're kind of in the same mess, right? But we still have discrete agreements with discrete breaches. So I guess it's not totally clear to me why the pending arbitration is necessarily dispositive of the specific breach claim. So I understand the interact.
So I guess I would say because there was a fraud in the inducement claim, and that has to do with the note. I believe plaintiff's brief says that claim doesn't even mention the note, but it does refer to it as the $2 million financing scheme. I mean, this whole note is what this whole deal between the two is what started the whole thing. So I mean, there's no question that both the arbitration and this case arise out of the same operative facts.
What about the same parties? I mean, I looked at the case law cited in your briefs and
Mhm.
I didn't see case law that indicated that this same parties requirement would be met here. Unless we just kind of agree with you that these are effectively the same parties, in which case it seems like maybe we're pulled back into the arbitration. But I mean, how are what case law shows me that these are the same parties for these purposes?
I don't believe that we need to get to the same parties if the issues would be preclusive.
Well, it needs to be the same parties and the same claims, right? It's both.
Well,
what the rules
I
say.
guess collateral estoppel, you can use it offensively or so. So the issues, if the factual issues are resolved in the arbitration, they would be preclusive here. And I guess I would,
The argument is there's fact preclusion from the prior first arbitration. Because it's the parties that produce the same things. Fortunately, it's clearly it's not the parties.
it's not the parties, although it is they're controlling, it's their affiliates, it's their controlling members. But yeah, the fact issues would be, I mean, if they find that there was fraud in the inducement, it validates the note. And then also, I mean, the bottom line of the arbitration is it's gonna, with all the breach claims, it's gonna decide who owes what. And
Counsel, I'm not totally following. It seems like the argument you were making was under the first file rule, which I understand,
Yep.
sounds in similar ways to some of these preclusion doctrines or whatever, but I'm also not sure they're synonymous, right? Because what you're saying is the first filed rule is, well, you can't file this because this other one already exists. It seems like collateral estoppel and res judicata would be there to then say, well, then here, in this proceeding that is still going on, here's what happened there, and therefore it should, be binding here. So I guess I'm not. How do am I right that these are not synonymous principles? The first filed rule and the preclusion doctrines that you're invoking?
well, I believe I did cite case law in the brief that it might have been unpublished, but it talks about it's in conjunction with this rule, and it says that it means res judicata principles apply. And I took that to be broad as in both claim and issue preclusion. And then I believe that I cited a case also unpublished, Jackson Phelps versus DePiro. And it's basically giving the collateral estoppel law that says, and, it's talking about the issue that was essential in the first case determined by the arbitrator. So the trial court correctly held that res judicata and collateral estoppel bar the plaintiff's claim in that case. So I was thinking that those principles applied here.
Understood.
And I guess the last thing I would say is that the damage claim in the arbitration, I believe, at least I'm not totally up on where the arbitration is. I believe they had the proceedings and they're waiting for an opinion. But the damage claim was $52.5 million. So that would sort of outweigh whatever is owed here.
And for the first breach claim, what is the specific breach that you're claiming happened first? Breach of what?
So I believe the first breach, there's the capital call, and then also just the breach of the operating agreement.
So you're not claiming that there's no claim that the plaintiffs breached the note first. It's that they breached other agreements first.
Correct.
Okay, understood. Thank you.
Any other questions?
I think we've got it. Thank you. Plenty of time for rebuttal. Good morning.
Adam Barrett on behalf of the appellee. I think based upon the question I've heard that the panel understands the issues here. RIL Financial is not a signatory to the operating agreement. In fact, it was a very complicated structure where RIL Financial is nowhere found on this. Instead, you have an argument where appellant is trying to conflate who the controlling person is, basically pierce the corporate veil as to try to bring the lender into into this arbitration provision. Incorporation language in the operating agreement is very clear. It only incorporated the provisions, definitions relating to the loan. It could have as a trial court.
Well, yes. So how do I know this? I mean, how do I know the arbitration doesn't relate to the loan? I mean, an arbitration provision is kind of a, a procedural mechanism. The loan is addressed in the operating agreement. How do obviously you could have chosen to incorporate the operating agreement entirely. That would have made it very clear that opposing counsel ones, they could have also chosen to incorporate more narrowly with specific provisions identified. Here we just kind of say related to the capital contribution loan. So how do I know
Well,
that
because,
arbitration is not related to that loan?
well, one, I can tell you that there was no claim in the arbitration. RAL Financial was not a party to the arbitration. I did handle the arbitration, which is still pending. I can tell you that they did not incorporate, as the trial court judge said, the dispute resolution provisions. Nowhere was that even addressed in the Wayne County action that led to the arbitration. And it couldn't have, because the idea here is that the note, which they don't dispute, matured. So what wasn't an allegation of default. It wasn't an allegation of anything else. It was that the note itself matured. And that did not happen until December of 2022. Arbitration started 2 years prior to that.
But I guess I'm not, maybe you can link it up for me, but I guess I'm just wondering in terms of just the language of the note. It talks about the provisions of the operating agreement that are related to the capital contribution. And my understanding of one of opposing counsel's arguments is that, hey, the arbitration provision was one of these provisions in the agreement that was related to the loan.
Then it should have said that, right? And that's the other thing, I think, with the argument, which is they are identifying that this whole note is identified as it relates to these dispute provisions. Yet, what about the guarantors? There's three guarantors here. This is Mr. Barbat and Mrs. Barbat and Mrs. Barbat's trust. They're not signatories in the operating agreement. They don't argue that the guarantee action against them, the claims against the guarantors, somehow should be consumed into it. Instead, it's this kitchen sink approach of trying to say somehow that while we don't dispute liability, we've got these doctrines that I think, Judge, you picked up on directly, which was not the same parties, no allegations of privies, and the like. So I believe the trial court did not err in this. He gave them multiple opportunities, and even the trial court in his 16-page opinion commented that what they've done is just thrown a lot of stuff at me, asking me to find an answer for them. And ultimately, there was no answer. They're liable under the contracts that they signed. So unless there's any other questions of me, I'll rest on my brief.
No, I don't think so.
Thank you.
Thank you very much.
I mean, again, I would just make one point as to the guarantee. There still has to be a debt owed before the guarantors are liable. And our point is that the jurisdiction for that to decide that is in the arbitration.
All righty.
Thank you.
Thank you. Matter is submitted. Thank you. You have a nice day. Maybe get to go see the president. I hear he's in town. Item number 2, case number 370-829, Rehab and Mobility Systems v. Department of Treasury. Morning.
Please the court. My name is Wayne Roberts. I'm here on behalf of the plaintiff appellant Rehab and Mobility Systems LLC. Rehab and Mobility Systems is a specialty provider of medical devices sold pursuant to prescriptions to disabled individuals, catastrophically injured disabled individuals. It doesn't operate like a Walgreens, where the government would like you to believe somebody walks in, a healthy person walks into a Walgreens and can buy Band-Aids and diapers and those types of items. And that's what we're talking about. Nothing could be farther from the truth. The department is attempting to collect sales taxes on specific sales of these prescription medical devices sold to some of Michigan's most vulnerable, catastrophically injured citizens. These individuals suffer from paralysis, as we pointed.
We're here on a statutory construction argument. I understand you'd love to argue policy and we'd love to argue policy with you. But it seems to me that this case presents itself as an issue of whether or not these items fit within the meaning of the statute. So let's get to it. I think that my disagreement with your client's position here is simply this. The purpose of this, if you look at the purpose of the sales tax, you start with this assumption that everything is subject to a sales tax, and then the exemptions are narrowly construed. I'm sure you don't disagree with that as a general thesis. So if you're asking us to say that bandages, diapers, gauze, these things are tax-free because they're by prescription, I think then they would be tax-free. Then you're saying that they're always tax-free, and it doesn't really matter who gets it, if it's a disabled person or if it's Judge Mariani. As long as it's by prescription, it's tax-free. Is that your client's perception?
Well, we'd like to take a step back. The Michigan Supreme Court just recently confirmed that although exemption statutes are an exception to the general rule, they are construed based on the plain language of the exemption statute, and there's no need for a canon to strictly construe them. And the language is plain here. That
But
a prosthetic.
if it is plain, then every time a doctor prescribes a gauze or a Band-Aid, it's tax-free.
Well, the legislature made the decision to
Is that
include,
your position, yes or no?
no, No.
Okay, then
Well-
your position is premised on something different, correct?
well, I mean, the way you phrased the question, I just wanted to address supportive device. The legislature chose, and yes, they chose to defer to the medical professional as opposed to the tax collector to determine what items are going to be required as a prescription sale. And they did that.
And I guess, I mean, I'm sorry to interrupt, but I guess my question is, under your offered interpretation, what would a doctor prescribe? Not just to a catastrophically injured individual, although I know that's, your client's clientele, but that's not a statute. So what would a doctor prescribe under your interpretation that would not be a prosthetic device? What physical item?
Yeah, that would not potentially be.
It seems like you're arguing, a Band-Aid supports the skin when it's injured, and things like that. So I'm just trying to figure out what isn't a prosthetic device under your interpretation?
Well, a durable medical equipment would not be a prosthetic device. That would be covered by a different statute.
Okay.
But the legislature made a conscious decision. And in 2004, one of the things that the court.
Counsel, can you answer my question though? I understand that the legislature made its decision. It chose the words it chose. So we're trying to understand them. So can you give me an example of something under your interpretation that a doctor would prescribe?
A wheelchair would not be.
Because it's durable medical.
Yeah, that's a different.
Okay, what
type
about
of
something
item.
that isn't durable medical equipment? Isn't a mobility, I don't have the language off the top of my head.
Physicians prescribe, they prescribe vitamins. They prescribe a whole host of different types of items to promote health. But
And why would that not be? How do I know that's not?
well, it's not a medical device. These are all medical devices they're regulated in the Code of Federal Regulations that have been cited by both our side and by the government and relied on, talk about what these devices do, and they're FDA regulated. They're medical devices. So there's a lot of items that wouldn't be medical devices that a physician might prescribe. They wouldn't be covered.
Such as,
The vitamins,
okay.
vitamins,
So,
healthcare products.
But anything that goes on the skin would be covered.
Because we defer to the physician, yes. and not to the tax collectors for this.
So any Band-Aid, no matter how small or how big, would be tax exempt, provided that it was issued
Well,
by prescription.
I submit that that's not the question before the court today because we have a specific set of items. But that we don't have that exact Band-Aids. We have bandages. But these are bandages that as our expert described.
Not sure your expert's testimony gets heard, but anyway.
Well, I mean, she had very fact-based testimony about how she applies these bandages and different wound care materials to the patient.
Let me ask you this. Distinction you're making is if it's prescribed. So if I went in to CVS in my hometown and bought bandages, which are available on any shelf, they'd be subject to sales tax. But because a doctor prescribed them, they're not subject to sales tax, even if I'm using them for the same purpose.
Well, but
Is
you
that
wouldn't,
your
you wouldn't,
argument?
but you wouldn't be. You wouldn't be because the physician would have determined that you had a serious enough wound that you need to be prescribed.
What if my
bandage.
prescription ran out and I was up north and I needed them for whatever I needed them for? And that's what the purpose was, but I could buy them over the counter. Why? That because they're not subject to my prescription?
Yes.
So the prescription is what is the key differential, and what statutory language do you base that distinction on?
The prosthetic, it has to be sold pursuant to a prescription. And it has to be,
And what section is that in the statute? That it says it has to be issued pursuant to a prescription.
that's in the,
205.51, right? AQ.
But 51A defines prosthetic. But the exemption, I believe, is in 54.
Is it 54? I'm
Yes, I
sorry.
believe that's in 54. I'm sorry.
You are correct, A1K.
Yeah. 54 requires that these items are sold pursuant to a prescription. And that's when the definition of prosthetic comes in. And one of those, they're not limited. These prosthetic devices are not limited to replacement devices like mechanical arms or like artificial legs, but
Let me
they're,
ask you about that a little bit. So I mean, I know we have a specific definition of prosthetic device for purposes of the statute. But I think if you ask somebody, just, a layperson off the street, what they think of when they think of a prosthetic device, they think of a certain thing. And I understand the statute can define it how it wants, but it still shows the words prosthetic device. So when we're thinking about the right way to interpret this specific definition, what role does that word's prosthetic that the statute is, choosing to define play in how we think about it? And
I think, yeah, Judge Mariani, I think that you hit the key point because it defines prosthetic and it doesn't leave it to common
Mhm.
on the street view. It
still
says
uses
it's a
prosthetic,
replacement device
Mhm.
or it's a corrective device
Isn't the key
or
term
it's a supportive
device?
device.
Isn't the key term a device, not something that supports a device?
Well, a supportive device qualifies as a prosthetic. So a supportive device is something different from a replacement device.
So a
And it-
Band-Aid is a supportive device.
Yes. Yes.
That's your
It,
position.
well, a bandage, not a Band-Aid brand Band-Aid, but a bandage used by the patients that
Rubber
receive these
gloves are
prescriptions.
a supportive device.
Well, gloves have there's a different, they are integral to and required to be used with these other items. They don't have the same, supportive background as the other items that are actually placed on and worn on the body.
But that's still lumped in with how is a glove a supportive device?
those are used, they're necessary and integral to the use of the other items.
Lubricant, I guess, is the same.
Yes, yeah,
explanation.
yeah. Gloves and lubricant are different from the primary devices that are worn on the bodies of these disabled people because they're paralyzed. Their skin is weakened and they have no blood flow. So these items are placed on the skin.
Let me ask you a different question, and this kind of goes back. What's your position? Because it seems to me that the Rule 89 differs from what the current statute is.
Yes. Yeah. Well,
And it's different.
Yes.
And there's language that was there that is now no longer there, right?
yes.
Tell me why that is not a conflict and the rule essentially should be disregarded in the statute,
Well,
plain language control.
well, the rule should be disregarded to the extent it's inconsistent. And so if the only requirement is that these prescription items help a disabled person to lead a reasonably normal life, the reasonably normal life part's been removed. Right? There's still prescription items, but where they're consistent is there's a list of examples. And the Michigan Department of Treasury in 2004, the statute was changed, and it wasn't changed to change tax policy. The amendment was enacted so Michigan could join streamlined sales tax. And that Minnesota did the same thing, has the same statute, and allows exemption for exactly the same products. Michigan did that in 2004 by keeping the rule in place. The state published that rule with the examples for almost 20 years before the department decided, oh, we changed and we're going to make a retroactive change because of that 2004 amendment. They didn't change policy in 2004. They changed to a definition, but they kept the rule in place to provide those examples as guidance.
And I don't have that list in front of me. Can you, how many, are any of your items specifically enumerated on that?
They
list?
list gauze and bandages as two, and it's an illustrative
Right,
list.
it's illustrative.
So, and that's what Minnesota, see, Minnesota joined in 2005, 1 year after Michigan. And it didn't have a rule. So there was some confusion. So in 2019, it promulgated a rule exactly like Michigan's. So in 2019, we were identical, parallel with Minnesota. And then 23, Michigan decided, no, we're going to go back and we're going to very narrowly look at this. And we're going to do, what you mentioned, Judge Mariani. We're going to say, what's the common meaning? Let's not look at the definition. Let's not look at supportive device, correct device. Let's look at the common meaning. And that will allow us to tax these sales to disabled.
Where do you draw the line then in terms of, I mean, you talked about lubricant and you talked about gloves being supportive and integral. Where do you draw the line?
The legislature deferred to the physicians with the prescription requirement.
So anytime,
that's where I would
so
defer.
anytime a doctor prescribes it.
That's the way this lays out is the legislature has placed the reliance on the physicians and the medical professionals.
Not vitamins. Or are there other like orally, taken medications or, shots or, I mean, I guess what could a doctor, again, back to what can a doctor prescribe that would not, that you'd say, you know what? No, that's not.
Well, does it support? I mean, the Court of Claims referred to supportive and just said that means something that supports. But the base word is support.
Any doctor prescribed treatment, presumably is there to support that patient's health.
Yeah,
Right?
well,
So support can be broad or it can also be more narrow in terms of like
Well-
physically load bearing.
but a supportive device other than contact lenses, right? That's the statute.
That's corrective.
Right. Right.
So it's
so-
replacement, corrective, or supportive, except for
Well,
dental.
but supportive devices it excludes contact lenses. So that means a contact lens is a supportive device. Otherwise they wouldn't have
I think it was
excluded it.
excluding it from that list of replacement.
No, it's right in supportive device other than contact lenses. It's right in the supportive device.
Means a replacement, corrective, or supportive device other than contact lenses and dental prosthesis. I'm not sure that other than necessarily attaches strictly.
but
to
it's in
supportive
C.
device.
Right. But that's in supportive devices right in C. Yeah. so it follows it. But this supportive device then needs to support a weak portion of the body. So all the things that you could buy that don't support a weak portion of the body or a weak body part, so they don't assist, they don't help, and they don't hold up weak body parts. That's where, things like vitamins and different shots and things, they wouldn't qualify.
When
It's
you say
only the
support,
things.
you mean like a physical support?
Yeah, well, like the way when they wrap somebody's paralyzed leg with gauze and wound care materials and medical tape, and it's all part of a prescribed treatment plan. Those items are supporting that. We
Because
can,
it's providing some form of physical
right,
support.
right.
to it.
Yeah, we're not saying this is just, you can go into CVS and buy the Band-Aid because you cut your finger. It has to provide some level of support to that weakened skin that's caused by, the paralysis or the other serious problems.
But I guess the issue I see or I struggle with is, let's say it's an individual prosthetic device has a prescription for whatever bandages it is, and they're on vacation up north. And they need more of them. They go in and buy the same item for the same purpose, and it's subject to sales tax. Because they don't have their prescription with, it's at CVS and there's Walgreens there, right?
Yes.
That's subject to sales tax. Same purpose, same durable good, same individual, subject to sales tax there. But if they're back downstate and they go into their normal CVS that has a prescription, no sales tax.
Right. That's exactly how the statutes operate. If I buy a wheelchair today out here at a supply store, I pay sales tax on that wheelchair. But if I have a friend who is paralyzed and has a prescription, we go back and I buy the same wheelchair with that prescription. Now it's exempt. You're exactly right. The legislature has deferred to the physicians in every one of these cases, every item of durable medical equipment and every item that's a medical device.
But the category, even though but not everything a doctor prescribes, I think the legislature aren't we informed by that it says the sale of prosthetic device, durable medical equipment, or mobility enhancing equipment isn't prosthetic device in addition to the specific definition that we've talked about. Aren't we to interpret what prosthetic device is by looking at, is it similar to durable medical equipment or mobility enhancing equipment? It seems to me that those things are all durable, like a prosthetic device, durable medical equipment, or mobility enhancing equipment. Those things are all durable. They're not one-time or short-time uses.
Well, that's a good point, because in durable medical equipment, in the definition, that's why we look at the prosthetic definition, because in durable medical equipment, they say it's only durable medical equipment if it can withstand repeated use in the statute. That's in the definition. So when you look at the definition of prosthetic, it doesn't have that. It's making clear. There's a clear distinction. And that's a very fine point, that prosthetic does not have to be subject to able to withstand repeated use. It can be exactly this. And that's why it's consistent with the FDA regulations and the Medicare rules that we've cited that treat this, they reimburse and they cover certain items. And these items are included in prosthetics. Prosthetics is used in a variety of ways that is not that what you'd say like the common man on the street term of what a prosthetic is. And I think that's a fine point, that they're very different, because durable medical equipment is defined to have that ability to withstand repeated use, where the prosthetics not. If I have a time, I'd like to reserve that for rebuttal.
All right,
Thank you.
thank you.
Good morning, Wesley Margison, Assistant Attorney General representing Treasury. I think the court has identified the key dispute, it's statutory interpretation. And the Court of Claims hit the nail on the head when it started talking about the definition of device as something designed for that purpose. So the statute explains what a prosthetic device is, defines that by first explaining that it's a replacement, corrective, or supportive device other than contact lenses, et cetera. And then just describing what it does. Before you get to what use it might get to, it has to be something designed for that purpose. And that prevents us from going down the path of where does this end? Because then if all you look at is, well, this could potentially support some sort of a weak part of the body, as in any possible damage to the skin. A pinprick, could a cotton ball be a prosthetic device that you put over your finger after you take your blood? If you're a diabetic, it keeps us from going down that road of anything that you put on the body that is prescribed by a physician. So it has to be designed to be a prosthetic device. And as the Court of Claims explained, these are all things that are used to cover wounds or assist in medical treatment, and they're not prosthetic devices.
So,
Period.
so categorically, everything that's listed here categorically does not fall within the definition of prosthetic device, regardless of how it's being used with respect to.
Yes, it has to be designed for a prosthetic device. It has to be designed as a prosthetic device. Because otherwise, all you're doing is looking at, is it prescribed by a physician and worn on the body? And the rest of the statute means nothing. The
Well,
first
is it
clause,
designed to be supportive, right? And your position is that gauze is not
I would agree with
designed
that.
to be supportive, and tell me why exactly.
Gauze is designed, if you look at the CFRs and the product information we have, gauze is designed to cover a wound or absorb blood or fluid or things like that. It's not designed to support anything. It's a stretch to say it supports, skin that's open. That's not what it's there for. It's there to help the healing process and absorb fluid and prevent.
It doesn't
infection.
take the place of this
Exactly.
in forever.
Exactly. Yeah.
Is that something that we should look at? Is this a temporary fix, so to speak, as opposed to a permanent? It would seem to me that if it's more of a permanent fix, it would inure to brother counsel's benefit. Would you not agree with that?
Well, the statute doesn't describe temporary or permanent. It's just,
But I mean, we're trying to come up with, one of the great legal fictions that this court has developed is that legislatures are presumed to know the words they use, which is of course a joke. But we have this, I mean, to his point, we have this very open-ended set of definitions. And we, as my two brethren have stated, we're constrained by what those words are and what do they mean. So I do think that the court, I don't want to say the lower court, I don't believe that it is a lower court. Court of Claims said, hey, it has to be this or that. We have to also be careful not to add words that aren't as brother counsel told us. So if you could give me your definition, if you were writing the opinion, how would you define these differences? What would be your definition?
well, I would start with the fact they have to be designed to have a replacement, corrective, or supportive purpose. You can't take something that has some other purpose and then say, well, we're going to use this as a prosthetic device and have that qualify. Otherwise, that first clause of the statute means nothing. And then it has to be used for one of these purposes.
What is a supportive purpose?
It has to support or weaker deform part of the body.
No, that's skipping to how
So-
it's functionally, but I mean, like, you're talking about a supportive device. How do I define supportive device before we get to the uses for which it can be prescribed?
I think you have to look at the statute as a whole, and I think to define supportive device, you do have to look at sub 3, that it has to be designed to support a weak or deformed part of the body, and that to me indicates something that is that you can't stand up on your foot or something for some
Doesn't
reason.
that go to what Appellant's counsel said, that like gauze, for example, if you're missing your leg from the knee down before you put your artificial leg on, put a gauze sock or you wrap it in gauze. Is that not a supportive, or it replaces the missing portion of the skin that's there?
I wouldn't say it replaces the missing portion of the skin. It simply goes over the skin to help keep out infection. And I wouldn't say that it supports that weak part of the
So
body.
is infection a malfunction of the body? So the gauze is there to prevent a malfunction of the body.
I would say that infection is not necessarily a malfunction of the body, the way the statute has it written, to where a prosthetic device addresses that. And as far as Rule 89 goes, Treasury didn't maintain anything for any length of time. The second the statute changed in 2004, that rule is invalid. We have clear case law on that, and the language itself is what controls, not what Minnesota did, not
Because
what.
their point is that you didn't, you're saying that the statute, just by necessity of legal operation, validated the rule, but it wasn't officially formally rescinded until later. So-
Yeah. It's by operation.
So that's a bookkeeping matter, not a legally operative.
Yeah, I think I would agree with that statement.
I'm sorry, just ping pong you in tennis back and forth, sorry. But I guess my question is let's assume we say, okay, Rule 89 conflicts. Okay, so we go back to the statute. I think Brother Counsel would say, well, even under the plain language of statute, we still these items are still exempt because of for all the reasons he argued, right? Do we need to, if we agree that Rule 89 is invalid or conflicts with the statute, therefore is invalid, do we need to go through and analyze each item that is challenged in this case? Or are you arguing for a broader rule that covers the specific items in this case and would be applied more generally to a broader category of items?
If I understand your question, what we would argue, Rule 89 doesn't apply here at all.
Right.
And it
Let's
does
say we
apply-
agree with that. Don't we still need to look at the specific items at issue that they treated as sales tax exempt, and you're saying, no, those weren't sales tax exempt?
Yes, but under the statutory definition, not
Under the statutory
Yes.
definition.
Yeah.
And I guess what I'm asking, it kind of goes to what Judge Borello said. How would you define that? Are you defining it, we only look at it as applied to these 5 items? Or are you arguing for a broader rule that would cover these 5 items plus, probably another 15, 20 items that they sell? Or are we going to be back here, 6 months from now and they say, well, these items are exempt for the same reasons, and then we've got a rule again?
I would say we would need a broader rule. I'm not aware of another court case interpreting this definitional section. So explaining what that means would be beneficial to Treasury. So I would say that we do need a broad rule about what this means and what the item has to be and has to be designed for to meet that definition.
Thank you.
Thank you.
Thank you very much. Rebuttal, sir.
There is no broad rule, and there are other cases because the department only recently abandoned the list of examples in the rule, right? We're not arguing that rule supersedes the statute or overrides it. Of course it doesn't. But to the extent it's consistent, the fact that it kept being published in the Michigan Administrative Code every year, and although Judge Perello, you indicate that legislators may not be aware of all the terms, but they certainly were aware they were publishing this rule, and the Department of Treasury is acutely aware of the way it was enforcing the statute, and it was granting exemption to these specific types of items.
But to your point, this is not a new request for exemption from
No.
you. This has been going on since,
No.
before
Right.
the statute enacted, subsequent.
Yes.
And what we're seeing is a change.
It's always been the rule. It's always been the rule,
Policy.
just like, and we can say Minnesota is not relevant, but it has the exact same statute from the streamlined program. And it, unlike Michigan, it made clear in 2019, yes, of course, these are prosthetics.
But
They're
if
prescription.
that's the case, this wasn't your client's first contention when they were seeking to, if you will, minimize their tax liability. They initially didn't even make this argument to Treasury, according to the referee's decision. So if this was, as you say, the way it's always been, why wouldn't that have been their lead argument?
Well, I wasn't involved in the informal conference. I don't know. I don't know how that, I don't know how that was handled. And I don't know if you've had experience with informal conferences, but a lot of things happen. They are very informal. The referees are generally not lawyers, and often both sides are represented by non-lawyers. So it's hard to
Okay.
articulate what might have happened there. But I think as to the point about is an infection a malfunction, I think the answer to that has to be yes. How can an infection?
Well,
Not be a
infection is
malfunction
is the
of-
introduction of a
Right.
foreign
Right.
bacteria or virus. It's not necessarily
Well,
your body. And, I think of a malfunction, I think of my computer, it doesn't malfunction because I spilled water on it, right? It malfunctions because some of its internal operations just, break on their own accord or stop working. The virus or the bacteria that causes the infection, I guess that's where
Yeah.
I struggle.
and so then the infection leads to the weakness in the body. It leads to a weakness. So again, I think this is why the legislature chose those terms, because they're more broad. And that's why we don't just have a replacement device, so that you'd have the common, what you would think of as Oscar Pistorius when he was running the Olympics with artificial legs, right? Those replacement devices, clearly are prosthetics, but the legislature went farther. And it only did that because it joined Streamline. Remember, that joined 23 other states now. And all they're doing is trying to get uniform statutes in place so they can incentivize and lobby Congress to enact a federal law that will force states to use all the same rules, as opposed to like 11,000 jurisdictions have different sales tax rules now. So that totally different from tax policy changes.
Before you sit down, before we let you go, talk to me a minute about and help me understand the issue with the 2017 tax lien or whatever. I forget the exact term.
Well, what in the audit process, the first thing that the government issues, not the first thing, but the first thing that leads to appeal rights is called an intent to assess. It's a bill for taxes. So they issue this bill, and that's the amount that I owe. If I owe $100, I get an intent to assess $100.
Yep.
If that's a negative, then that means the government owes me $100. Right? And they issued this negative intent to assess, and it was appealed, and without any discussion, it was just canceled. So that's my receivable. That belongs to rehab and mobility. And without any explanation, and I think it probably took 6 months before we got a real response with a really complicated set of work papers that said, well, we applied that. We took that money and applied it to other liabilities, the other liabilities that were being contested. So that's why, we would respectfully request that the Court of Claims be reversed.
So in your math, you'd say, okay, we're right that the sales tax exempt for 18, 19, and 20, there's no problem that, let's call it 300K plus. So we don't owe you 300K. And a matter of fact, you have the 2017,
Yes.
you owe us another 100K.
Yes,
You applied
because you
that to the
applied
300.
that. Yes,
I got what you're saying.
Yes.
Okay, that's how that all fits in.
yes.
Okay, that helps.
Yeah. If there's anything else,
Very good job. Thank you both very much. It's a very difficult issue. It's obviously one we've struggled with, and I want to thank you both for your assistance.
well, rehab and mobility systems, very empathetic group of people doing a lot of good work for disabled, and they thank you for your attention and your time.
Thank you very much, counsel. Matter is submitted. That brings us to item number 3, case number 373-425, McAdoo v. Ware. Good morning.
Morning, may it please the
Sir.
court, Keith Bank appearing on behalf of the, plaintiff appellant in this matter. This decision at the trial court truly left me nonplussed when I was told by the litigator about it. I was shocked beyond reaction. This is a,
Claude Rains level shocked, or I don't know if you are old enough to know that reference, but
I do not, unfortunately, Your Honor.
Casablanca. I'm shocked to discover there's gambling going on here, sir, to which the next line is your winnings.
Oh, no. This was true shock. This was true shock,
This
Your
was
Honor.
true shock. Okay.
This is an uninsured motorist case, and our burden under the contract is to establish that the driver or owner of the vehicle was uninsured. And in this case, the only evidence of the vehicle being insured is the testimony of the vehicle owner. You have the testimony of the driver. That's an admissible hearsay. She said, yeah, I think he had insured. That's hearsay. We go to the driver, who, by the way, was incarcerated at the time for fleeing and eluding police in a motor vehicle. And he testified that he had insurance and gave us the name of 4 insurers. We go to these insurers. None of them have a record of him being insured at the date of the accident. We go to the Secretary of State. We pull the driving record of both the owner of the vehicle and the driver of the vehicle at the time. Both have extensive histories of driving without insurance, both with convictions within a year of this subject accident of driving without a license. We get the Secretary of State report on the vehicle, the tags on the vehicle. It's flagged by the Secretary of State, the license plate, for confiscation because of irregularities in the registration and the insurance process. So in spite of all this, and defendant is an insurer, they have tools to locate coverage. They don't have any evidence of, or present any evidence of him having any kind of coverage. So in light of this overwhelming evidence refuting his testimony, Judge Barry accepts his testimony as truth and dismisses the case. It quite frankly ignores the rules completely with regards to summary disposition. They present evidence that he was insured. We present evidence calling that testimony into question. In fact, if I weren't a plaintiff's attorney, I would probably argue that we were entitled to summary disposition on the issue because of the overwhelming evidence calling his testimony into question. There's not one iota of corroborating evidence that this gentleman was insured. In fact, all the evidence shows that he was not. Barry dismissed the case nonetheless. Now, defendant's argument doesn't seem to be with the evidence. Their argument seems to be procedural, that this evidence was all submitted as part of a motion for reconsideration. That straight up misrepresents the record. The initial motion for summary disposition filed by the defendant had no evidence at all that either Powell or Ware were insured. The entirety of their motion was shifting the burden to us. They said, well, we have a contract. Plaintiff has to establish that these people were uninsured. And they can't establish that. That's the entirety of their motion. There is no evidence attached to that motion establishing that either of these people were insured at the time. So, and in response, we simply said, look, it's not our burden at the summary disposition stage. They have to come forth with evidence establishing insurance. They didn't. And we also provided the police report that shows no insurance on it. And said, this is our evidence. There's no insurance. And also, by the way, these people have not appeared. They've been defaulted. So again, this supports that there's no insurance for these people. Judge Barry, instead of dismissing the motion as she should have at that stage, then allowed all of this supplemental discovery to take place. She allowed the deposition of the driver and the owner of the vehicle. She allowed all of this to be submitted, and all of this evidence was submitted as supplemental pleadings. So this was not us scrambling at the reconsideration stage to refute the evidence.
So the record was built out in the supplemental pleadings prior to the determination, not at the reconsideration.
Yes, and this was done by Judge Barry, who ordered all of this in light of no evidence from the defendant that there was any insurance. So if you step back and you look at this, even if you apply the abuse of discretion standard for a motion for reconsideration, the motion for reconsideration should have been granted. There's simply, all we have is the testimony of a man sitting in jail for fleeing and looting, that Barry took his bond and said, in light of this testimony, and this, which we have evidence questioning the credibility of the testimony, she took it as credible and found that no juror could conclude that the plaintiff was uninsured. mind you that she put us in the position of having to prove a negative, which is very difficult to begin with. And we did the best we could. We went to the insurers that he listed. None of them could corroborate it. Defendant, with their industry-specific tools to locate coverage, couldn't locate coverage. We have the evidence of him having a history of driving without insurance and irregularity in the tags of the vehicle itself. So, this seems pretty straightforward that there was an error here, that this, at the very least, should reach a jury on a question of fact as to whether or not Mr. Powell was insured. The trial court simply got it wrong in a fairly egregious manner. So with that, I will rest unless you have any questions, and I will save the rest for rebuttal.
All right, we'll listen to what sister counsel has to say. Morning.
Good morning, Your Honors. Bailey Cowger on behalf of the defendant Appellee Auto Owners. Your Honors, this was a C-10 motion, and as my brother counsel kind of set up, we first moved and supported our motion, and then on the burden of the non-moving party is to set forth evidence that would establish a fact issue. We don't believe that occurred. He mentioned the trial court gave another opportunity for the record to be supplemented in order for that evidence to be brought forth. And that did not occur on their end. As far as what supports.
Let me just pause you that. So you disagree, because the way I understood plaintiff's counsel was that Judge Barry said, hey, I want supplemental pleadings, and they did provide supplemental pleadings that refuted your reliance on the driver's statement that he had insurance by including the letters and that he was his driving record and all the things he listed. You say that that's not accurate? Is that what you're saying?
I just want to clarify what was provided in the supplemental briefing as compared to the motion for reconsideration. So the supplemental briefing, I believe there were 3 sets of exhibits. The final set of exhibit included a couple of those letters, and then the motion for reconsideration included more of those letters.
What about, let's set aside why is it not enough to say a couple of letters? Why is that not enough? If it was a single letter, why is that not enough to say, hey, at a minimum, we've got a fact issue of whether or not this guy was actually insured?
Our position on the letters is at most they might create an inference that there was an insurance for the offending vehicle, but that isn't enough by the terms of the policy to establish that the vehicle itself was uninsured.
You don't have to establish it. I mean, that's an ultimate merits determination, right? We're looking at fact questions.
I should say to create a fact issue. One of the pieces of evidence we relied on was the adjuster's testimony. In his deposition, he explained that when we're dealing with an uninsured motorist claim, we look for affidavits of no coverage. One of the reasons that we look for that is to verify completely that there isn't actually insurance on the offending vehicle. And those were not provided in this case.
When did the carrier discovery report come in?
The carrier discovery report was considered during the summary disposition phase.
And that said his policy was canceled, right?
Well, one of them. In our position on the carrier discovery report, I have 2 responses. The first is that it noted the potential for 3 policies, but the report itself only referenced 1. So in our briefing, we explained it at least is incomplete as far as how that report is kind of
Is
considered.
incomplete another way to say there's a fact issue?
No, Your Honor, I would say that it's just not, and to use the adjuster's testimony, it's not definitive on the issue of the uninsured status. It is considered.
Issue to be definitively determined at a later date by a fact finder.
I think that goes back to the burden in opposing our motion is to say, have you put forth evidence that establishes the fact question? The carrier discovery report is a good example of something that gave at least 1 policy that was canceled, and as the adjuster explained, is not used as the final say.
When did the citation that he was cited for driving without insurance 5 months prior?
Yeah,
When did that come in?
that was also before the trial judge, and I just wanted to note there was some
Prior to
discussion.
the motion for reconsideration?
Yes, Your Honor.
Okay, so why not those 2 things? So those 2 things coupled aren't enough to create a fact issue?
At least as it relates to the driving records of the offending vehicle owner and the driver during the accident. Those didn't necessarily, those records didn't refer to the offending vehicle only. A lot of the times those records said passenger vehicle, which our position was it wouldn't have established that the particular vehicle at issue in our case was uninsured. And then the separate report that I know Brother Counsel mentioned as far as fraud in the application or insurance issues, that record didn't specify which it was. So again, those could create inferences, but we don't think it's enough to create a fact issue as to the uninsured status. I just want to go back to Mr. Powell's testimony. He was asked twice. He was asked initially, did you have insurance? He said yes. He was asked, how are you sure you had insurance? And he explained he would have had to procure insurance in order to get a license plate for the vehicle. And the trial court found that to be testimony that established that the vehicle was insured. And then I just wanted to note the police.
The key question is whether it was insured at the time of the accident, not when he got his license plate or the license plates were obtained for the vehicle.
Yes, Your Honor. In that same testimony, he explained he would have months prior gotten the insurance in order to get the license plate prior to the accident. The timeline was that he would have had it at the day of the accident because a few months prior was his birthday when he would have been renewing the license plate. I also wanted to just highlight the police report because I know Brother Counsel mentioned it. There was an indication of NA under the section of the report that would explain whether there was insurance. Both of the officers were deposed and explained that that NA indication wouldn't necessarily mean that insurance didn't exist for the vehicle. It just relates to whether they have the ability to ask that question at the time of the accident. And they both explained that they didn't in this circumstance, just given the nature of the injuries and other priorities. So I'm happy to answer any further questions, but we otherwise ask that this court affirm the trial court's order.
I don't believe so. Thank you
Thank
very
you.
much, counsel. Nice to see you again.
Thank
In rebuttal, I think by defense counsel argument, you can kind of see that in their mind, there is absolutely no way for us to establish uninsured motorist coverage. As soon as you get someone involved in one of these accidents, if they lie and say I had coverage, somehow their argument is we don't get uninsured or contractually provided uninsured motorist coverage. That can't be the rule. Mr. Powell gave this testimony in prison for fleeing and eluding.
You
And
made that point.
yeah, and we checked his testimony. Everyone came back, no, they can find nothing. And they want us to prove this negative. So apparently our job is to go to every insurer, subpoena every insurer, every financial institution. That can't be the case either. And I want to point out that the initial motion did not have this testimony. And that was all done through the supplemental process as well. They did not have Mr. Powell's or Mrs. Ware's testimony at the initial summary disposition stage. So their initial motion was deficient in that it did not remove this from the jury because they had no positive evidence of insurance when they initially filed their motion. So I think if you just step back and look at what the law is and what lawyers do, big picture, there's an egregious error here. They presented weak evidence of insurance. We've refuted that overwhelmingly. The trial court should not have dismissed this, and this court should correct that wrong. Thank you.
Thank you both very much. Matter is submitted. Next, we'll take up the combined cases of Allison Barkley versus City of Southfield, case number 369608. Colleen Corey versus County of Oakland, case number 370050.
Here's what I found.
That's good for you. Case number 370112, 370580, Alward versus Village of Beverly Hills, 370583, same parties, 372060, Ashley versus City of Birmingham, and 372076, same parties. Good morning.
Good morning, judges. My name is Dean Yotis. I represent the appellate homeowners and later the appellee homeowners. I think this case can best be categorized as a no harm, no foul case. Not that I believe that I committed a foul. If there was any shortcoming in the service in this matter. But I think a combination of the court rules, specifically 2.1182, 2.105K3, 2.102C, and 1.105 demonstrate the error of the trial court's ways in striking under MCR 2.115 plaintiff's first amended complaint. So there was a complaint filed. We filed our first amended complaint, served it together with the unexpired summons. We have to keep in mind the purpose and goal of all the service of process rules are timely notice to the opposition. What they really want to do here, though.
Hang on a second.
Mhm.
Do you know what that feedback is I'm hearing by any chance? All right. I'm sorry. Yeah, this one's turned down. Or, okay. Now I'm sorry, we're getting a bad reverb here and
Nope, no need to apologize, Judge.
thank
Want
you
to make sure
very
you can
much.
hear.
That solved the problem.
Yes.
Go ahead, I'm sorry.
Yeah, how about it, since we got a break, I'll ask you a question.
Yes, sir. Yes, sir.
You can blame him, not me, all right? Based on your argument, that the way you were setting it out, would you agree that the plain language on the rule governing amendments, that it contemplates that an amendment once of right without leave of court is to occur by the plain language only after the first responsibility?
No, I
Okay,
don't believe
explain that to me.
Okay. What we have, in my view, is a statutory construction issue here because it's the word within is ambiguous. Okay, that's, the reason is it has two different meanings. I pointed out the Black's Law Dictionary and this other legal thesaurus with it. Both of them were the last time the word within showed up in it. If you're talking about something like within a house, it's bounded by the house. Okay, but when you're talking about relation to time, it merely, and I got the Latin term, it merely sets the external term. Okay, the word within, when it comes to time, does not fix the terminus quo or first day on which a First Amendment complaint could be filed. Rather, it merely establishes that 14 days after being served with the responsive pleading is the terminus ad quem, or last day you can amend the complaint. And again, that's because of the definition of the word within.
What are we to make of, I'm sorry, go ahead.
Go ahead.
I was just gonna say, what are we to make of the fact that the rules were amended, where the
Right.
prior version of the rule kind of laid it out that it was clear that you could do it anytime up to and including within 14 days after responsive pleading, and then they changed it.
Right. I would submit, Judge, that it was also clearly bad grammar. Okay. Because before or, remember, the court rule was changed in 1985. And in that, before that, it said before or after. Okay. That's redundant when it comes to the word, when you look at the definition of the word within as it relates to time. Because remember, within only sets the end point.
So you're saying within just replaces the phrase before or after?
Right, right. So it would be grammatically correct to omit before or. It's a grammatical improvement. That's consistent with the entire arc of Michigan law. Okay, we've always been evolving towards more liberal employment. This is an enfranchising court rule, you know, to allow you to amend a complaint, even if you didn't get it right the first time, so you can have a fair chance on the substantive issues. All of the case law talking about problems with amendment have always been because they're too late or they'd be futile. This is a situation where as soon as we realized there was some need to amend, we amended, immediately served them. In fact, well, I won't get off on that.
Why is
tangent.
it, why am I wrong to interpret the rule to say, well, actually, what it does is set forth a very clear, reasonable procedure so that courts and litigants aren't overwhelmed where maybe they get, you know, if you've got multiple defendants, couple of them get served the original complaint, a couple of them get served an amended complaint. Address that for me.
One of the reasons why it's important to allow amendment in service of an amended, so the defendants don't have to hit a moving target. Okay, once you amend the complaint, they have that and they know, hey, that's what's on the register. That's what needs to be responded to. Okay. So there's no danger there. There's no danger whatsoever. There's still very limited opportunities to amend.
So let me ask you, would it have been permissible, let's say you observed the original complaint with the original subpoena. But before they answered, you said, oops, I've got to make some corrections, add a claim, whatever. You file an amended complaint. Could you still serve it under that original subpoena?
Well, and I want to answer your question as directly as possible, but this is what I believe. I believe in this case, before there was anyone on the other side, I amended the complaint. I think certainly that's permissible to do that. But if they if they provide a responsive pleading, is that the?
No,
question?
prior to a responsive pleading.
Okay, prior to.
So you served the original complaint on City of Southfield
Yeah.
under the original subpoena.
Right,
They haven't answered yet or filed a responsive, well, they haven't answered yet.
Right.
Filed a responsive
Right.
pleading. You go ahead and amend.
Yes.
Could you serve it under the original subpoena?
yes, based on the definition of the word within, I can still do that because it'd be within 14 days of any responsive pleading. My time hasn't run. You take two published Michigan cases support my position. Malberg, they say it doesn't involve the new court rule. I'll be honest, I'm not sure, but I know the court rule was changed in 85. And this case was decided in June of 86. So I'm not sure about that, but I put it in the brief, so I'm not going to, unless you have questions, but Badeen was certainly after. And Badeen very clearly went with the interpretation I just provided of the word within. I'm not going to go over all of that again, but they clearly agreed. They have no published case law to support their position that contradicts those published cases and the definition, in my view, of the word within.
Was taking me down memory lane there, counsel. The old court rules used to have to quote them GCR, what was it? GCR 1985,
Yeah.
blah, 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 yeah.
I think-
Back when we
Mhm.
did MSA and MCL.
I had written down a GCR for this one too. And I forgot to add, I looked for staff comments on this so-called change. There was nothing there on this issue at all. In fact, I wrote it down. The 1985 staff comments only specifically addressed subrules A, 3, and B of 2.118. So you
Your
take,
point, counsel, is that if they were intending to work a substantive change in practice here, you'd see that.
that's
in the
correct,
notes.
Judge.
Otherwise, construing it as stylistic cleanup is the better way to go. Is
Yes.
that your position?
That is. And I looked into the statutory construction rules as far back as I could. This Hayden's case, I thought was the best way to explain if in the book was in Statutes and Statutory Construction by J.G. Sutherland, kind of a horn book. Second edition by John Lewis. They talk about Hayden's case, Heydons, back in common law in England. And they said, well, if you're trying to interpret statute in a change, let's look to what mischief it's designed to correct. I didn't see any mischief either. I didn't see any problem with amending too early the complaint. It's just the opposite. The concern is always that it's too late, that it'll be futile, or it makes it unfair to the other side to have a fair trial. That's when the issue of amendments and problems come up, not doing it early to try to give notice as soon as you possibly can.
Counsel, let me ask you, but just the court rule about, striking the amended complaint.
Yes.
Is I think you stress is permissive, discretionary. And I guess, you know, on the one hand, maybe that militates in your favor of, you know, the court could choose to allow this. But I mean, does it also leave space for the court to say, hey, you know what, I don't like how this was done. And so I'm going to strike this amended complaint. You know, I think we have two of the judges here went that route, although perhaps for different reasons. So, I mean, is it abuse of discretion, even if we agree that say, hey, this isn't prohibited by the court rules? You know, what tells me that Judge Rowe, for instance, you know, couldn't reach the decision he did?
Right.
How is that an abuse of discretion?
Well, okay. So are you asking me to address 2.115, the brevity of striking the complaint, the First Amendment complaint first?
Yes. Yeah.
Okay.
And, you know, like I said, I mean, I think Judge Rowe gives us an example, right? He's he agrees with you on the dismissal point, but then says, hey, you know
Right.
what? I'm going to strike this amended complaint, you know, serve the original one, then you can go about doing your thing. Like, is that an abuse of discretion?
I don't believe so at all. No, in fact, I don't necessarily think that would be the perfect solution based on my explanation of the word within them. But I'm fine with that. I was fine with it, and I don't think it's an abuse of discretion. I think it's a principled decision. I think it's like the test where sometimes people look at can't remember the psychological test. Some see a rabbit, some see a duck, or different things at the same time. You have intelligent people sometimes looking at this issue in different ways. Now, the reason why I have a problem with the trial court in Southfield here, Parkwood, Allison, is she on her own. There was no one on the other side bringing a motion. Took the drastic action of striking the pleading. Now, the court rule says it is a drastic action, but you can strike a pleading if it's, quote, drawn, and then it has other, like, it doesn't say filed improperly. It says drawn. I think that's more appropriately designed for situations where there might be some scandalous things stated in a complaint. There might be things that are clearly inappropriate for other reasons, but it doesn't say filed. So I'm not even sure MCR 2.115 applies. But I think under these circumstances, when there is no question that the defendant received notice of the action in a timely fashion, comporting with all the purpose of the process of service rules of, you know, timely notice, allowing people to be made aware of the action. There's no question here in my mind that what she did far exceeded the range of principal outcomes. And as you pointed out, Judge, 2.105K3 states as clear as unambiguously as possible, an action shall not be dismissed for improper service unless the service failed to inform the defendant of the action within the time for service. That's exactly what happened here. There's no dispute about that. I could go, well, I'll let, unless there's any other questions.
Let's hear, yeah, I was gonna say, let's hear from them and you can tell us why they're all wet. No pun intended, by the way.
He's been saving that for weeks now.
Actually, I came out and I went, what a stupid word to use, but not surprisingly. Good morning.
Good morning, Your Honors. My name is Scott Petz with Dickinson Wright. We represent the county defendants in the 4 trial court cases that are before this panel. To my right is Mr. Curlew. He represents 3 city defendants in 3 of the cases. And then behind me is Ms. De Lorenzo, who represents 1 city defendant in 1 of the cases. Not sure if you want them to put their appearances on the record, or I drew the short straw, so I'm the one talking. And
I was gonna ask, are you the choir master here of this group, or?
I'm the short straw person. So I am going to.
If they want to put their appearances, certainly, we know who Mr. Curlo is, and we know who Miss De Lorenzo is. Her senior partner sent her on a crappy case the last time.
Well,
Tell us why, Mr. Yodis, why we should why we should just kick Mr. Yodis to the curb and his clients as well.
Yeah, obviously not the way I would phrase it. What we want are court rules that are enforced as written. And in this situation, we have 4 complete failure of service of process cases. Holiday tells us what a complete failure of service of process case is. It is the failure to serve the summons and the associated complaint before the summons has expired. If we do not enforce 2.102E and 2.118A1 as envisioned, what happens is we end up with chaos. And for example, I heard Judge Mariani ask about the Beverly Hills case, and I took note of this. Mr. Yodis was asked if he was fine with having the First Amendment complaint struck in the Beverly Hills case. And he said, yes, that is what I heard. But what happened? The Beverly Hills court struck the First Amendment complaint appropriately and then told the plaintiffs to serve the original complaint that had never been served on any of the defendants months after the summons had expired. And so that's the result we get. And 2.102E is an automatic dismissal. That is what is required. And when the clerk or the court does not enter that dismissal, the way it is brought to the court's attention is through an MCR 2.116C3 motion, which is insufficient service of process.
What are we to make of the plaintiff or the defendants who responded to and answered the amended complaint and then didn't include as an affirmative defense failure to serve or improper service?
Judge Truvilcock, if that is a question that the panel wants answered, I'm going to provide my.
I asked it.
Yes,
Oh,
no,
yeah.
yeah, no, I get that. I'm going to give you my thoughts on it, but do know that that is not a county defendant at all. What we're talking about is Mr. Curlew's client.
Actually, anyway, you said you drew the short straw, so I took that as meaning you were arguing, or they're going to argue that point later. Is that what you're saying?
What I would like to do is answer your question and then give the podium to Mr. Curlew to the extent he wants to answer further, because he has the clients that are implicated by the answer. But I do want to tell you, I can read the court rules and I know what happens. Once you fail to serve the summons and the associated complaint by the time the summons is expired, the case is deemed dismissed. Even though there is no order by the clerk of the court or the judge in that case, the case is already deemed as dismissed. So anything that happens after that date is of no consequence. So when we talk about an answer to a unilateral, invalid, improper First Amendment complaint being filed by a defendant, it's in a dismissed case. With that, I'm happy to cede the podium to Mr. Curlew if he would like to add additional.
No, we're going to finish with you first. He can answer it later.
Thank you,
I'm
Judge.
sorry to step in and step on your toes as choir master, but let's have you finish up, shall we? Thanks. So when you say that I understand your argument about it's null, but so that I understand the facts of this case still, you don't dispute that service was made within the proper time, do you? Your clients are not saying that the summons had expired, correct?
Service of process, the term service here is supposed to mean something, and it's supposed to mean you have received the summons and the associated complaint. What was received is set forth in our briefing, and that is a summons and a First Amendment complaint. So I don't believe that constitutes service under the complete failure of service of process rule. You can't just give the defendant any document with the summons. You have to give the defendant a appropriate and associated complaint with the summons. And I direct the court to the hip slap case and the Durfee case, which kind of talks about the importance of the summons and the complaint, the technical nature of all of it. And I also want to point the court to the Holiday case, because I'm not trying to be harsh, but I do understand that the result could be harsh. And this is something that the Court of Appeals did recognize in the Holiday case. and indicated that if a different result were to occur, you need the Michigan Supreme Court or the legislature to make a change. And 30+ years later, we're under the same rule, Your Honors.
Right, so, but holiday number one involved no summons at all, correct? That was the issue in holiday. Yes.
Yes,
Okay, so there was no appraisal that an actual lawsuit had been filed.
that's false,
Okay, why is that false?
because there was a complaint served. It was a complete failure.
In holiday?
Yeah.
There's okay, so, but there wasn't so because there was a complaint served that indicated that it had been filed. That's what you're saying.
That is, yes. And in fact, when you look at the briefing, I believe plaintiff's counsel suggests that once we got a summons and a first amended complaint, we could merely go on the register of actions or the internet and pull down the complaint.
Because what I read in holiday is, quote, is the summons which informs the defendant of the fact that an action has been commenced against him. Right? That's what holiday says. So that's where I'm, I guess, understanding their reasoning in terms of what they're saying, why the summons was important. Now, the other thing I see in holiday is it says that it recognizes this tension, right, between the deemed dismissed and the I want to make sure I get the court rule right. Well, it forgives errors in the manner or content of the service, right? But not a complete failure.
Yes.
You're saying this is a complete failure, but I guess how do I know this is not a failure? How do I not know this is an error in content?
Well, I think the and means something in the court rules.
Sorry, you said the what means something?
The and.
Oh,
It's
okay.
the summons and the complaint, not any document, not any complaint, not a third amended complaint, not a first amended complaint that violates the rules. It is the summons and the complaint. And this is a complete failure of service of process case, period. And in terms of,
You have, I guess, where's do you have a case law that addresses a specific factual circumstance?
I think this particular factual circumstance doesn't occur regularly. But you did mention, so I do not have a specific case in which there are 4 cases with 4 different results where
Well, I'm not that specific. I guess these all share a common fact pattern here, right? Of we have a summons that was issued in connection with a complaint. There was an amended complaint filed, and then that original summons was served with the amended complaint, right? And what I'm wondering is, in that fact pattern, do we have case law that says that is a complete failure of service of process?
I
I
believe.
know holiday. I know what holiday says. I'm wondering if there's another case that kind of addresses this circumstance.
Judge Mariani, we believe that Holiday, Durfee, Hip Slop, and the actual language of MCR 2.102 D, E, and F covers this situation. The dispositive issue before this court is decide whether this is a complete failure of service of process case, period. So
Getting back to Judge Mariani's point, why is this not just a technical failure? They sent the wrong draft of the complaint. I mean, you don't disagree that you received the summons before it expired, right? All the clients, all the defendants received a copy of the summons saying a lawsuit had been filed against them prior to the expiration of that summons. Can you agree with that?
that divorced from the dispositive complaint, yes.
Just the summons, right?
Yes.
Just the summons. And an amended complaint naming the same defendant and the same parties was received by all the defendants. Is that right?
That's false. Parties were added, for example, to the Birmingham case.
Parties were added, but that wasn't true for all cases, but some cases, parties were added.
Yes,
Okay. And it included all the original claims that were in the original complaint. Is that correct?
there are differences and added an event,
Okay, it
whole-
added an event.
a whole new set of claims.
Okay. But otherwise it was all the same complaint. So that's the only difference?
No, I mean, it is a long complaint, but the major thing is an event was added. An event that could potentially be appropriately added at an appropriate time. You serve the summons and the complaint as required under the court rules. That is how you effectuate service of process. If you fail to do so, that's a complete failure of service of process. I do want to address,
Let me ask another than practical question. Let's say we agreed with you. Said, what happens then with this case? Is the service, could they still bring the claims? Can they serve that?
the case,
Is it dismissal without prejudice? You're saying it's without prejudice, right?
Your Honor, it is without prejudice. That is, I hopefully set forth well in our brief. 2.102E is fair neutral. It is merely telling you what happens when you fail to serve the summons and the complaint.
Well, my question is just a practical one. Help me understand sort of what are we doing here? Is, I've had this happen a lot of times. There's errors in service or whatever, and we get an agreement and say, okay, look, you screwed up the service. You could go back and do it. Let's just agree we'll answer the amended complaint. Why is this important enough to be in front of us?
Yeah, I mean, number one, look what happened when the same situation was in front of 4 different trial court judges. Number two, the 2.102E is tied to substantive rights. It is tied to the right to have the statute of limitations told so long as you effectuate complete service of process, which means the summons and the complaint. If you fail to do so, you no longer have the benefit of the tolling.
What
So
about equitable tolling?
there is no basis for equitable tolling. 2.102F sets forth the only conditions that must be met in order to revive a case for which dismissal needed to occur under 2.102E. And F is not fulfilled. They're not arguing it. They're arguing things like 2.105K3, which go to the method or manner of service, technical errors. For example, maybe you email the summons and the complaint that is actually properly before the court to a party. That may be a 2.105K3 case, but the Holiday case tells us you cannot use 2.105K3 to save a case from dismissal under 2.102E. The only rule that can be used to resurrect the case, because it's deemed dismissed without any action by the clerk or the court, is to fulfill the conditions of 2.105, strike that, 2.105 or 2.102F. I apologize for that. And let it be noted, I know your honors have delved into the briefing. When you go back to the Southfield case, a motion for reconsideration was initially filed by plaintiffs when the court appropriately struck the First Amendment complaint and appropriately dismissed the case pursuant to 2.102E. And knowing that the motion for reconsideration would not get the relief needed, plaintiffs then filed a 2.102F motion to essentially revive the case, but they can't fulfill the conditions of 2.102F. And when you look at the briefing, and there's a lot of briefing here, and there's a lot of rules thrown at you, whether it be 2.105K3, 1.105, a lot of rules thrown at this court to essentially say, please do not let this harsh result occur. And I would submit to you to look at Holiday and the acknowledgement that this could at times lead to a harsh result, but defendants deserve to be served appropriately. And it's a complete failure of service of process when they do not even get the complaint associated with the summons. With that, I reserve time for rebuttal.
Any questions? Thank you, counsel.
Thank you, your honors.
Good morning, Mr. Curlew. How have you been?
Good morning. I've been much improved. I had cancer in 2024, but
I
I'm much
know, you look
improved.
great. by
Yes,
the way.
thank you.
Were you up at the Supreme Court, or did I see you arguing recently with up there or not?
Not real recently, but I have been there twice in the last year or so.
Okay.
I looked a wreck at the time, so if I look terrible, that was me. Yeah, it was right on the completion of chemotherapy, and I was not looking good.
Well, I'm glad that you're doing well.
Thank you. Douglas Curlew on behalf of the Village of Beverly Hills, City of Southfield, and City of Royal Oak. And I caught things from each of the judges that I want to address. First, I'll just say that Mr. Petz addressed basically our position, which was said repeatedly in our briefs as to why the answers that were filed on January 9, 2025 mean nothing. It's because the cases had already been deemed dismissed by a self-executing rule 5 weeks prior. But to address a couple of things that were said, one, you've spoken in one of the earlier cases about the importance that we're dealing with statutory construction, which of course those rules also apply to the court rules interpretation. And I want to emphasize that in the service rules, what the rules use is the definite article, the.
Doesn't that mean the operative complaint?
It means the operative complaint.
But if it's not wrong for them to file an amended complaint as they did, why is that not the operative complaint?
Well, but because they didn't hit, there was none of the triggering factors to allow filing an amended
Well, I
complaint.
guess so, right. So I guess let me assume we're in a world, maybe I guess in the prior court rules, where it was okay to file the amended complaint. Would there be a service issue here?
Under the prior rules, under the old fashioned rule before?
Yeah.
Uh,
Let's go with that. Where it makes, that rule, I think, makes very clear that it's okay to submit your amended complaint.
right. And I don't
And
think,
if you had just served that amended complaint with the original summons, like if what happens here, would we have an issue?
yeah, well, I can't think back to what the GCRs used to say, whether they required the complaint or a complaint. So that's really where we would hit the crossroads there, because if those
Well,
rules, like the rules now, required the complaint using the definite article, then you would have to serve the operative complaint. I guess if you have an amended one, would it then be operative under that old rule, and that could have been served. But that's not what the rule is now.
Why can't we read the complaint in at the same time with 2.118 and say that the amended back to the original. So therefore it is. Why can't we read those in conjunction?
Well, if you have a validly amended complaint, perhaps you could do that, but we don't have a validly amended complaint. None of the judges are, there was no motion made. There was no response made to allow a unilateral amendment by the plaintiff. There was no motion made to allow a change by the judge, and none of the judges ordered an amended complaint. That's why they all struck them. They didn't want, that's why they were struck, because the rule had not been followed. So the complaint, as far as these cases were concerned, was never served.
So counsel, your opposing counsel had pointed to Badine as case law indicating that what happened here was okay in terms of the amended complaint. I understand your argument about the change in the court rule. Is there any case law that tells me that your understanding of how this court rule works is correct? Because I have case law from him, published case law, that says this is okay. I haven't seen case law from the defendants saying, actually, no, this is not how this court rule as amended now works. Am I missing anything, or is that correct?
I can't cite you to a case on that, but I have in my notes, then I think I put in my brief that the Badine case, the actual issue dealt with class certification, not the service.
But they
So-
didn't, but they had this, that was a step they had to take in that analysis. They didn't reach their decision about class certification without first concluding that the amended complaint was validly filed as it was.
Which requires us to infer that they made an issue, that they took that as an issue. After all, the court only reviews issues that are brought to it. I don't know whether that issue ever was decided, or it certainly wasn't decided, whether it was even before the court or discussed by the court. I don't think that case applies because it's not clear enough that it applies to the particular situation here. And I wanted to address something that had occurred to me, and then Judge Trebilcock brought it up. If we follow the plaintiff's reasoning, now I represent oftentimes, especially in federal cases, groups of police officers who effectuate an arrest, or groups of sheriff's deputies who oversee a detainee in a prison where there's multiple defendants from the same entity. If we follow the plaintiff's interpretation of these rules, they would be able to file a different version, an amended version of their complaint differently on each of those defendants. I mean, consider as counsel used the word chaos, if you get multiple different complaints, not just one amended complaint, but a bunch of differently amended complaints served on multiple different defendants in the case, which is what his interpretation of the rule would allow, that is chaos. That just makes it impossible for any of the defendants to know what they're able to do. I would just say that as also it seems a little incongruous to be particularly forgiving in this case, given that service would have been so easy. Why were we on the 90th day at the very end without having this thing served? It's not hard to serve a city or a village. You go to the clerk and give them the complaint. And I can say driving home from Beaumont Hospital at my chemotherapy, I passed the Royal Oak City offices, the Village of Beverly Hills City offices, and the Southfield City offices on the trip. They're all right there on the road. They're easily served. There had to be some device, some motivation for why this was done the way it was. And even if there was no pernicious intent in this case, and I am not implying that to Mr. Yodis in this particular case, but that opens the door, leave aside this case, if the rules are interpreted in that way that allows the amendment, the free amendment we're talking about here, that can be used very perniciously by lawyers who are not, by lawyers who want to use it in that manner, to the great detriment of fair litigation for the defendants. And so I don't think the rule should be interpreted in that way, not just for the sake of this case, but for the sake of what that would forebode in other cases where lawyers could use it to disadvantage a defendant unfairly. I believe my briefs were quite thorough. If there's any other questions, I'll field those. Otherwise, I'll let Ms. DiLorenzo have her say.
Any questions? It was, as always, Mr. Curlow, very well briefed. Thank you, sir.
Thank you.
Very well argued. Morning again.
Good morning again. Josephine DiLorenzo on behalf of defendant City of Birmingham.
Now, do you want, we're going to give you an opportunity to out whoever it was who sent you on the prior case. If you want to put their name on the record.
I do not. That person does not actually work at my firm anymore. So,
well, even better.
So, but we still work together. So, I just want to say that the arguments in our brief are similar to those made by the county and the other defendants. So I was going to rely on my brief, but if you still have questions, I could answer.
Any questions for counsel? Thank you very much, counsel.
Thank you.
Nice to see you again.
Good to be here.
Been a while. Rebuttal, sir.
So this idea that Mr. Petz raised about a quote, complete failure of service, the one case Judge Mariani pointed out in Holiday, the summons was not included with the complaint. Okay, and there was a letter sent by the lawyer representing the plaintiff. I am not now serving you with process in this case. I don't know how that could be any more distinguishment. That was the one piece of authority that they have. I think it favors us. I think it supports the notion that in a case like this, where you have in hand a first amended complaint together with an unexpired live summons, that's notice 2.105K3, and it's mandatory. It says you shall not dismiss it because they're aware of the action. So talking about awareness, after Judge Anderson on her own struck my first amended complaint in that case, I called counsel and told them all what happened on the other case before they even did anything. I wanted to make sure they understood what was going on. So they had complete notice of everything that was going on. As far as any possible sinister motives or conspiracies, I can assure you nothing of the sort. 1.105 talks about all these rules focusing and being interpreted with the eye toward economics and efficiency and not getting caught up in technical problems. Why would they want to have to get served with a complaint that was going to get amended? And as Mr. Pett said, I think one of them did add a new event, which explains why there's no conspiracy. I'm trying to make this more efficient so they can answer that and file another complaint where they have to answer two complaints, which isn't efficient and it's not economical.
Billable hours.
Well, now we're talking. But I think we're getting to what they don't want these homeowners to have their day in court, because one of the earlier events, we were right up on the statute, and that's really what's going on here. They want to close the door to these homeowners. They don't want them to have their day in court. That's what's going on. Now, the billable part, that might be a part of it.
I have a question for you, a substantive question. So to Judge Trebilcock's point, in terms of how we interpret this court rule, why is it not right to think that, well, maybe we set this limit to just add some order to the process here to clean up some potential messes, different versions of the complaints flying around, all that sort of stuff. You just kind of say, okay, you serve the original complaint summons. Once you get the response to pleading, then you can do your thing. So why is that
To
wrong?
me, it's the old floodgate argument we hear in all the cases, Judge Wilder said it very well in his opinion in Badine. He said, no, there's still very limited opportunities to amend your complaint. And there's rules in place. Before we amended it in 1985, we had many years with no problem. Where was the chaos then? There was no chaos. Yeah. The floodgate chaos thing that, when you got nothing else, you talk about that. And that's what they're talking about. There's no chaos. And if you look at Badine, Wilder talks about it in very clear terms. And that was a situation where there could have been, because of a class action, which you correctly stated, in order to get to that decision, you had to make a decision on this 2.118 language, which he did. Just like on the Marlboro case, they did the same thing. They've got no authority, no published authority otherwise, but they want to talk about chaos. I don't think that carries the day, and it's not accurate. As far as 2.102 E1, he told you about why it was automatically dismissed, but he didn't tell you what the court rule actually says on that. It says it's not deemed dismissed to anybody who was served. Well, they were served. They're served. So that's the end of that discussion. That court rule is designed to have a case dismissed where someone is not served. They're served.
Isn't there argument though they weren't served because it didn't contain?
Right.
That's what
Which is it. This is interesting because if you listen to what they're saying, the associated complaint, there's nowhere in the court rule where it says associated complaint. They just started using this language lately. I don't even know what that means, associated. I think I know what it means. But as you pointed out, Judge Trebilcock, if you amend a complaint and it's okay, then it's the complaint. It is the complaint for all purposes. Okay. That's what we're saying here. It was amended. It should have been the complaint, and therefore there's no issue. Now, they want to talk about the distinction between a and the. My position is if they meant it to be only you can serve the original complaint, they would have said only the original complaint. That's how you solve that problem. This a and the distinction, I'm not buying it. I don't think that they meant to put it. I mean, that makes no sense. Why would you serve if you amended a complaint and that was the operative complaint? Why would you be serving a different complaint? That can cause confusion. So I don't understand the distinction between a and the is carrying the day, because the service of process rules were designed for notice, and notice was given in the best possible way. It satisfies all due process requirements, as the case law pointed out. 2.102C states a court may allow process or proof of service to be amended unless it clearly appears that to do so would materially prejudice the substantive rights of the parties against whom the process issued. Then an amendment relates back, absent unfair prejudice. Well, substantive and unfair prejudice has to do with having a fair trial. There's no problem here with the fair trial. The complaints were virtually identical. A couple of them, there might have been an additional party. I think one, there was an additional event. It just is more economical and more efficient for them to respond to a First Amendment complaint that was filed with the additional information. So for those reasons, in the Southfield case, we ask that we find that Judge Anderson abused her discretion in striking it. Remember, even if there was a shortcoming, you don't have to engage in the harshest possible result by dismissing these parties, these homeowners, from having their day in court. You could have taken the position, if you believe there was a shortcoming, like Judge Rowe, Judge in Royal Oak, I think it was Judge Cohen. He didn't see any problem with it because of K 2.105K3. He said they got notice of it, and they did. And that's what the service of process rules want to protect. They want to make sure you got notice. Holiday, totally distinguishable because there was a failure of the summons, which the court indicated, and that was even more important than the complaint because it directs you in terms of what you need to do next. Thank you for your time, judges.
Thank you. I'm going to give you guys brief rebuttal on this because we're still trying to figure out how we're going to go on this one. So
Thank you, Your Honors. In terms of the argument just made by Mr. Yodis, we refer the court to our briefs. For example, with the Royal Oak Court, which is Judge Cohen, he did not refer to 2.105K3. He referred to, I believe, 1.105, just general rules of construction and this idea of doing equity. But before this court is this idea of, does a court rule mean what it says it's going to mean? And I'm going to read MCR 2.118A1 up to the first comma. A party may amend a pleading once as a matter of course within 14 days after being served with a responsive pleading by an adverse party. You will see that after a matter of course, the language at any time before or is no longer there. The court rule is amended. And although not published authority, you will see, for example, the Kickham-Hanley case from 2019, the Jones case from 2024, dealt with a situation of no responsive pleading received, and they file an amended complaint. What happens? The amended complaint gets struck. And that was in a situation where defendants get a complaint, they analyze it, they file a motion for summary disposition, and the plaintiff just simply says, oh, here's my amended complaint, I filed it. Go answer that now. And the court said, no, that's not okay. You have to file a motion. And in this case, a motion was not filed. I do appreciate the questioning on Badine, a 2013 case in which you will not see a quotation to MCR 2.118A1 at all. You will not see analysis. You will not see that there's even a dispute as to whether the first amended complaint was proper. You will see no dispute as to whether the original complaint was served or not. So it is not a case that I believe guides this court on how to look at a rule and figure out what it means. Does it mean what the words say, or does it mean something different?
anything further? Any questions? Thank you. Mr. Curlow, anything further from you? Ms. DiLorenzo, anything further? I want to thank all of the attorneys involved in this case for submitting outstanding briefs and outstanding arguments. Thank you all very much. Giving us a lot to think about, and this matter is submitted. Thank you. Thank you very much. Good afternoon, everyone. Obviously, you were all here for our earlier session, so I won't go over what is expected. We'll just get right into it. Item number 5, case number 3727772, Kalal versus Sue, I believe. Good afternoon.
Afternoon, Your Honors. Kyle Kelly on behalf of Mr. Khalil. I understand the court has thoroughly read the briefs. I will endeavor to be brief here. I'd like to start with what this case is actually about, because I think the trial court lost sight of it a little bit. This case is about a man who was unconscious for 7 hours while undergoing surgery, where the medical team was in complete control of his body. And then he wakes up and his left arm is permanently damaged. It wasn't damaged before, but it was damaged after. So the question isn't about, or shouldn't be about, whether we can reconstruct everything minute by minute, second by second, hand by hand what happened during that surgical procedure. The question should be about, is there enough evidence for the jury to conclude that proper care would have prevented this injury? And I think there is. I'm going to start with causation as to Dr.
So are you claiming that this action rests solely on the doctrine of res ipsa loquitur?
No, no.
All right, well, if it
I
doesn't,
don't,
then
Your
you
Honor.
would agree with me that in order to go forward, you have to have evidence relative to the standard of care, correct?
And we do, Your Honor.
Okay, let's talk about what is your evidence relative to the standard of care as it relates to the nurses?
To the nurses, in that case, Nurse Dole testified that that it is incumbent upon the nursing team to ensure that the patient's arm is less than 90 degrees. Otherwise, it causes an injury. And she said, and I have it here, she was emphatic, a good nurse, a knowledgeable nurse, one that knows the job and knows right from wrong will make sure it's less than 90. It has to be less than 90. And then Dr. K backed that up and said that mispositioning the arm is a breach of the standard of care. Now, the issue seemed...
No, I'm just talking about the standard of care relative to the nurses. Did Dolt specifically testify as to what the standard of care was relative to the nurses, or did she defer?
She deferred as to the actions of the individual nurses, because again, she could not say who did what in a minute by minute blow in that room. But she did say that keeping the patient's arm at a 90-degree angle is a breach of the standard of care, and that a nurse, any nurse, should know better. And that a nurse that doesn't fix that
I don't think she did say that with all due respect, counsel. I've got most of her, I have most of her testimony in front of me, and she just says it means that something didn't go right. They are not negligent, but clearly something wasn't done right. So why don't we go back to my question in turn, just because something happens in terms of a median nerve injury, does that mean that someone is negligent? Answer, really, it's not just black and white. What we do is not black and white. Question, but you did agree with that median can and do happen in the absence of negligence. Answer, yes, they can. But quite obviously, the person went in there without this and came out with it. So something was, you know what I'm saying? It's not black and white as yes or no. I'm not pulling any definitive statement from that testimony. So what other testimony is there that perhaps I might have missed?
Well, because she does say, and this is at page 55 of her deposition, she said that a nurse will make sure it's less than 90. It has to be less than 90. Now, she's not testifying to causation because that's not her role, but she is saying that a nurse has to ensure that the arm is positioned at a less than 90-degree angle. So I think that is a definitive statement. And saying that, again, when she says it's not black and white, my read of that goes more to causation, which is not her purview. That's something Dr. K talks about.
Well, if it's not black and white, then what's the standard? There is no standard. It seems to me, again, when she says what she says, that obviously the person went in there without this and came out with it. We're talking not about traditional med mal, but res ipsa loquitur. But you've made clear that's not the basis of your complaint.
No, because she did testify that keeping the patient's arm at a more than 90-degree angle is wrong. She says it has to be less than 90. And a nurse that knows right from wrong will make sure it's less than 90. I perhaps in that she didn't, specifically say, quote unquote, is a breach of the standard of care to do X, Y, Z, but that's a fault of questioning, not a fault of the substance of her testimony. So when she says it has to be less than 90 and a nurse that knows what's right to do will make sure it's less than 90, I think that gets us there.
But my understanding too, and I don't know if you were there when this happened, but there was an off-the-record discussion wherein plaintiff's counsel noted for the record that Dole was not prepared to give an opinion regarding breaches of the standard of care because she was reserving the right to read the deposition transcripts of the nurses at issue.
So my understanding of that, and I was not there, Your Honor, is that She was not prepared to testify to the individual actions of the individual nurses because she hadn't taken their deposition. And and just if I can do a very brief tangent, something I did say in the brief ended up being incorrect. The defendants were right. There was a motion to compel that was filed, and it was denied prior to the summary disposition being denied. My error in the brief was that it had been filed prior to the plaintiff's response to that motion being filed. So the court did deny the opportunity to take those depositions. So my argument on that was wrong, and I won't even address it. But to your point, Nurse Dolt said that she couldn't say nurse A did this, nurse B did this, nurse C did this, but she did say nurses in general. This is the nursing standard of care to ensure that a patient's arm is less than 90 degrees. And in this case, the nurses didn't do that. And if you don't do that, it's wrong because it has to be less than 90. So I don't think she has to say.
How is that sufficient? I guess, tell me why is that enough? If I know that, nurses have to make sure this, then I don't know whether any of these nurses actually did anything to contribute to it. It seems like a material gap in proofs. So why is that enough?
Because it's enough for, I would say, two reasons. One, because if a patient is unconscious during surgery and cannot, and there's no video cameras there, if we don't know exactly who did what, minute by minute, blow by blow, but we do know a patient went into surgery fine and came out injured, and we have evidence that pinpoints the exact injury and the mechanism of that injury, and then we have a nurse expert saying this mechanism is or it is in the standard of care to ensure that the patient's arm is positioned this way to prevent this injury, and the nurses didn't do it. And we know they didn't do it because he was injured. And
sounds like a race ipsa loquitur then.
It's,
Again,
I suppose my distinction would be, I don't think it's res ipsa as to the existence of negligence. It may be encroaching on res ipsa for the specific mechanism or the specific, form that negligence took. But I don't think it's res ipsa to say that there is negligence, because we know, and now I'm going to Dr. K here for the causation, but we know the only way this injury happens is if the nerve is compressed or if the nerve is stretched. Those are the only two mechanisms, and either one is negligent, and either one causes this injury.
Talk to me a little bit about, you named the CRNA in this case, right?
I believe that's correct, yes.
Are you challenging that decision? Because I didn't see any, in the briefing, I didn't see any argument about the standard of care. I didn't see any
No.
citation to expert testimony.
No, just the nurses and the anesthesiologists.
Okay, so the CRNA, then that claim is abandoned on appeal?
As far as it was abandoned on appeal, my memory is, I'm not even sure if that was significantly addressed in the trial court briefing, but I suppose as far as the appeal goes, no, we did not address the CRNA.
Okay.
And I don't even think we had CNR and I'm not sure we had a CRNA expert.
Buettner or something like that.
Okay. But we did not pursue that.
Okay.
On appeal, and I'm honestly not sure the trial court addressed that much at all, but.
Okay,
To your
thank you.
point. If I go back to your point, Judge Mariani, it may be a bit similar to res ipsa if we are trying to define what happened every single minute of every hour in the surgery. But I think the evidence is clear that we have breaches of the standard of care, both by the anesthesiologist and the nurses. And the fact that Nurse Dolt can't say, well, yes.
just to tell you where we're coming from.
Okay.
You keep saying we clearly have breaches of the standard. We need testimony as to the standard. I don't mean to speak for Judge Mariani or Judge Trebilcock, but that's what we're looking for here, so that you understand. Where is the testimony about the breaches of the standard? Not there were breaches. What testimony was offered to satisfy that part of the statute? Do you follow where I'm going?
I do. And as
Okay.
far as Nurse Dolt goes, it's
Okay.
what I said a few minutes ago.
The arm was not properly positioned, correct?
And as far as the anesthesiologist, Dr. K was very clear even down to the mechanism of injury. It's either stretching or compressing, both of which are caused by arm mispositioning in the OR. So that is the specific testimony. And I don't think I understand the arguments as to res ipsa as it comes to the nurses, but I don't think that's a hurdle with Dr. K, because he was very specific about exactly what happened. And he couldn't pick between stretching or compressing, but the end result is the same. They both cause an injury. They're both the result of negligence. And the fact that he can't pick because he doesn't have a video camera in the surgical suite or X-ray vision to see what was going on in this guy's arm, he's identifying two causes, both of which cause the injury, both of which are negligence, and both of which are standards of care. And and the trial court wanted him to pick, and I don't think that is the standard here. It would require, whenever there are two possible mechanisms of negligence and both point to the same defendants, both point to breaches, both point to the same existence of negligence, both point to the same intervention that would have prevented it, the plaintiff still loses because you can't pick between the two. There was an example in the brief of if an individual has a gun in each hand and they fire both of them at the same time, if you can't say which bullet killed the victim, does that person get off of a murder charge? No, of course not. Because you know they committed the action, you know what the action did, and you know without the action, the injury would have been prevented. So it's still, in this case, negligence.
Counsel, just to be clear with Dr. K, are you suggesting his testimony implied?
As to where it reaches causation, yes, because I think there's a bit of a blurry line here. I think Nurse Dolt can say that failure of the nurses to maintain this guy's arm at a less than 90-degree angle is a breach of the standard of care, and I think she does say that. She says it's wrong. And from there to get to what causes his injury, then I think you have to go back to the causation testimony of Dr. K, saying that without this arm positioning, there is no compression or there is no stretching, and there is no injury, and he would be fine today. And he did testify to that. He did say he would be fine today. So obviously Dr. K cannot testify to a nursing standard of care, but I think a lot of the questions in this case are in a bit of a line, in that line between what is strictly standard of care testimony and what is causation testimony. And the testimony Judge Borrello asked about, where she said it's not black and white, that's a causation issue. Well, what injury occurs from what? That's causation. That's not something Nurse Dolt ever testifies to. So I think Dr. K, as far as the causation issues, does get there.
What do you have relative to Dr. Ford's conduct in this case? What evidence?
Well, he was.
Said that Dr. Suter, the CRNA.
I'm sorry, what? Did
Ford,
not,
CRNA.
yeah, not doctor. Thank you.
Dr. Sue, you mean?
No, I'm sorry, Ford. What do you have? What evidence did you present relative to the breach, relative to defendant Ford? Thank you, Judge. Jordan Ford.
Sorry, I'm just looking because I don't have that up top of my head.
That the CRNA?
Yes.
And so that's something that I don't think we really addressed.
Okay.
CRNA's actions in this. I don't think they were really addressed in the trial court either, for that matter.
Fair enough. Thank you.
So
anything else?
No, Your Honor, I don't think so.
All right,
Thank
plenty of time for rebuttal. Good afternoon, counsel.
I'm Christina Ginter. I represent defendants appellees Jordan Ford and Dr. Sue. What I understand as of today is that I don't believe plaintiff is requesting reversal of the grant of summary disposition as to Jordan Ford, the CRNA. So although I had addressed that in the brief, I will not address that unless the court has any other questions. So focusing on Dr. Sue, who is the anesthesiologist. Plaintiff's expert was able to identify or allege or assert specific omission of negligence by Dr. Sue, which was, according to the expert Dr. K, failure to put hands on the plaintiff's arm periodically during the surgery. I think in the brief, I addressed it as putting hands on once an hour, looking at that testimony again. I don't even think that Dr. K establishes that to be the standard of practice. I think what he testified to was, I personally put hands on every hour. I recognize that the literature doesn't say how often one needs to periodically assess or even the manner in which one has to periodically assess. I believe periodically assess means put hands on. I don't know what the standard of practice is with respect to how often that is done. So the issue in this case involving causation is specifically, can plaintiff establish that if Dr. Sue had put hands on the plaintiff's arm periodically during the surgery, would that more probably than not have prevented the injury? And plaintiff cannot establish that through the testimony of Dr. K. Because, again, we don't know how often hands would be put on the arm. We have no clear explanation, really no explanation at all of what kind of different or additional information was going to be gleaned by putting hands on physically versus looking at the arm. Dr. K talked a lot about positioning, didn't explain why looking at the arm isn't going to provide the information about positioning.
But your client says, no matter what I did, this is what was going to happen.
Well, that's true. That's
Right?
true.
And it seems to me that the expert, K, said, no. Two things. One, positioning, and two, to your point, checking. So those were, in his opinion, the standard of care. Is it your contention then that there was insufficient medical support for those positions?
Yes, but that's not the primary position on appeal. The primary position on appeal is that the expert Dr. K's assertion actually was with respect to the only person he's qualified to assert a breach of the standard of practice with respect to is Dr. Sue. He admits that he doesn't have any criticism of Dr. Sue with respect to the initial positioning of the patient because Dr. Sue wasn't involved in that. He admits that the only breach that he's asserting with respect to Dr. Sue is this putting hands on the patient periodically, can't define a time frame, can't explain exactly what kind of information we're going to glean for putting hands on versus looking at the patient. Can't explain what exactly we would have found, can't say when the injury would have occurred, can't say what an assessment at any particular time would have discovered. So that's the real flaw with this periodic assessment theory, is that in order to pursue a theory like that, you really need to be able to say, here's when the assessment needs to be done vis-a-vis when the injury would have occurred. The assessment would have been done before the injury occurred, and action could have been taken then to prevent the injury. He isn't able to establish that because he makes all these admissions about, I don't know when the injury occurred. I don't know when the assessment would be done according to the standard
Those
practice.
questions for the jury?
No, I don't think so. Not if the expert can't establish that initially. If he could say that, then yes, but no. Getting past that, even if on the face of it, his testimony was sufficient, he made a lot of assertions that were not scientifically reliable that we had challenged on a Daubert basis. The trial court had declined to address that as unnecessary, but it should be addressed, such as, for example, this assertion.
We can't address it, obviously.
Well, I think the court could. I think there was sufficient. We made the
can't do it.
challenge.
We counsel. We don't do Daubert.
Well, it isn't necessary.
That's not
No,
gonna
no.
happen.
Well, I understand that. I'm certainly not asking this court to do a Daubert hearing. I think this court can review what's been submitted and determine whether plaintiff demonstrated that it was
I would
reliable.
move to your next argument.
Okay, well, in the event that the court finds that the testimony on its face was sufficient, and I don't believe that it was, but if the court finds that it is, I do think that the case should at a minimum be remanded for that Daubert hearing as to all these assertions that were not supported by reliable literature.
That's an argument. Why would we want to take the fun away from the trial court, right? To conduct a Daubert. It seems to me that would be very mean of us. But anyway, points well taken. I don't think there's any question about Ford. I think brother counsel just, for all intents and purposes, admitted they don't have any evidence. So I think that's a done. You know, Sue's is another question, whether there's sufficient testimony here. It's close.
Was there, did defendant, I didn't see in there, defendant didn't present any evidence in terms of what the proper standard of care was other than Dr. Sue. Is that?
That's true. That's true. Correct. Yes, that's typical on these motions for summary disposition to say the plaintiff's expert cannot establish these elements. So yeah, that's what was done here. And Dr. Sue, of course, said that there wasn't anything that could be done, that these injuries do sometimes occur based on duration of surgery, the size of the patient, issues like that.
I was just going to ask it.
Yes.
Was there testimony regarding the likelihood of these types of injuries based on the characteristics of the patient?
That Dr. Sue testified about that briefly. I don't think he went into great detail, but he certainly said these things are increased. I think actually Dr. K acknowledged that those risks increase with the duration of the surgery, certainly. And the other experts who testified, including plaintiff's experts, CRNA and nursing expert, both acknowledged that these injuries can occur in the absence of negligence, which is a slightly different question. So I think there certainly was testimony that these injuries can occur in different ways and based on risks inherent in the surgery. I would touch on the issue of res ipsa with respect to Dr. Sue. Res ipsa was not a theory that was pled. It was something that was asserted by plaintiff in connection with the motion for summary disposition. I think it's a little bit of a red herring or misleading in this case because res ipsa typically is a negligence doctrine. It's not a causation doctrine, first of all, and what we're talking about is causation. But more importantly, it's typically a doctrine that's used or authorized to be used as sort of an alternative or a substitute for evidence of negligence where the plaintiff is not able to identify specific acts or omissions that constitute negligence. That just isn't the case in this case. Dr. K said, you know, I do have information about the surgery. I have the operative report, the anesthesia record. I have the deposition of Dr. Sue. I have depositions of other people involved in the surgery. Based on all this information, I'm not going to sit here and say, I can't tell you anything about what happened during the surgery. I'm going to say that the breach is specifically not putting hands on based on Dr. Sue's deposition. So I don't really think this is a true res ipsa case in that sense. I think it is a case in which there is a theory of failure to perform a periodic assessment by putting hands on, and the precise question is, can the plaintiff establish but-for causation as to that specific theory?
Anything further?
Questions?
Any questions? Thank you, counsel.
All right. Thank you very much.
Good afternoon.
Good afternoon, judges, and thank you. Alice Bell, appearing on behalf of defendant Harper Hutzel Hospital. And as brother counsel has acknowledged now that there are no pending claims on appeal as to Jordan Ford, then I will specifically rely on, as we did in our briefing as well, rely on the arguments made by sister counsel as to Dr. Sue, because my client, Harper Hospital's liability is all based on vicarious liability, imputation of vicarious liability to the hospital for specific agents of the hospital. So if Jordan Ford, the CRNA, is off the table, we're only looking at Dr. Sue, which has already been covered in depth, and then the nursing staff. Now, I'd like to just point out a few additional things based on the questioning that you were all giving. There were 3 specific nurses identified in plaintiff's complaint by name that were the ones involved in this: Nurse Gaynor, Nurse Mason, Nurse Vabel. Now, the vicarious liability claim depends on the plaintiff coming forward with acceptable proof that a specific agent committed malpractice. It's inappropriate, and that's based on the Cox case cited in our brief, to simply assign liability to a unit by saying this group of nurses is somehow liable without identifying specific breaches. The testimony of plaintiff's nursing expert, Nurse Stolt, was simply establishing the standard of care. Bottom line, she did not identify a single specific breach No single specific action by any of these individual nurses, one of whom was there for the whole procedure. One was there for approximately 12 minutes of the procedure to cover during a break, presumably, and one who was there for a little over an hour. So to equate them in one lump group is just simply inappropriate and isn't going to be able to establish liability that way. When it comes to the specific evidence of any breach of the standard of care or of causation, plaintiff simply failed to gather any appropriate evidence during the period of discovery, which is what went to the discussion off the record after her deposition. I was not present either, I have to say, but then also the motion to compel was filed. That was the very first deposition notice that plaintiffs had ever proffered for the nurses' depositions. They had never filed any written discovery requests regarding the actions or inactions of the nursing staff prior to that point, even though they were all specified by name from review of the records, and they were named in plaintiff's complaint individually. The first deposition notice didn't come until after this plaintiff's expert, Nurse Dolt, was deposed, and we sent plaintiff attorney a proposed stipulation to dismiss the claims against the nurses based on not having any evidence of breach or causation. Then they filed a deposition notice 6 months almost after discovery had closed. The motion to compel was then argued, and the judge agreed with our position that this isn't a motion to compel, this is a motion to reopen discovery, and it's inappropriate and highly prejudicial to our clients at this time. The plaintiff had ample time to gather evidence, and they simply failed to do so. And the case law cited by plaintiff in their brief saying summary disposition was inappropriate because discovery was not complete is simply misapplying those holdings. That's well established that if discovery hasn't closed yet, summary disposition might be improper if there's a fair chance of discovering evidence that could support the plaintiff's position. However, that's not what happened here. Discovery was closed almost 6 months prior. By the time the motion to compel was heard, it was 7 months after discovery closed, and they had never attempted to notice the depositions during discovery. They never got any written answers to interrogatories, for instance, during discovery. So they simply missed their chance. And just to touch briefly on the res ipsa angle in that regard, res ipsa, as I understand it today, as we stand here, Brother Counsel has disclaimed that they are trying to use res ipsa as a theory. But regardless, it's not meant to be a catch-all. Res ipsa isn't like the hearsay catch-all exception for negligence. You have to have the 4 specific elements laid out in our briefing in order to avail yourself of the doctrine. And they don't have it here because they are pleading specific breaches of the standard of care, and they are pleading specific mechanisms for causation of injury. So res ipsa is simply off the table. And that's all I'll say about that, unless the panel has any other questions. I'd like to also emphasize that the plaintiff never appealed the ruling on the motion to compel being denied. That is not on appeal before this panel today. It is only the ultimate grant of summary disposition that's being appealed. And Nurse Dolt simply testified consistent with her affidavit of merit, which all it did was mirror the allegations in the complaint. So the bottom line, when it comes to the summary disposition standard under C10, is the plaintiff has failed to produce the adequate evidence to rebut our claims in the motion, and therefore summary disposition was completely appropriate. Other than that, the only other point I would like to make too, based on the questioning, is that plaintiff counsel has repeatedly said the arm everyone said the arm can't be greater than 90 degrees. The only evidence we have is from the medical records that confirms that the arm was positioned at less than 90 degrees at the start of the surgery. And then there's no other evidence to show that it ever was altered. So they have no evidence to show that the arm was ever at a position other than the correct position. So that's, again, another way they don't have any evidence to show breach or causation as to the nursing staff. And then the hospital's vicarious liability, of course, as to Dr. Sue, would still potentially be available. But I would agree with Sister Counsel then again as to the arguments, all the substantive arguments, and also if for some reason the court is inclined to not find the grant of summary disposition or find his evidence lacking at this stage, we would also agree that then a Daubert hearing is necessary. And unless, does the panel have any questions?
Thank you very much.
Thank you.
Rebuttal?
I don't.
Thank you all very well. We will submit this matter. Have a nice day, everyone. Enjoy. That brings us to item number 6, case number 375914, In re Secreto Minor. Good afternoon, Mr. Miller. How are you?
Good afternoon, Your Honor. I'm doing well, thank you.
Good.
Joshua Miller from the Oakland County Prosecutor's Office, Appellate Division, on behalf of the petitioner appellee, Department of Health and Human Services.
Hey, who's your boss now?
His name is Brandon Barlog.
I don't know him.
Yeah, he's new to the appellate world. He was one of our circuit court prosecutors since
They made a trial lawyer head of the appellate division?
they did.
That's not good. I miss my friend Miss Day, as you well know.
Wow.
I thought very, very high, think very highly of your office. You guys really do outstanding work, and you should be very proud of the work.
File briefs sometime too.
Yeah, they file briefs down the
Absolutely
street
try.
here. Even on a murder case, we can't get them to. So anyway, I apologize for interrupting.
Oh, that's okay. I will say you will still see Miss Day on occasion. She is part-time, so
Here.
yes, we do still have the benefit of her experience and knowledge for as long as she wants to give it to us. In this case, we are asking the court to either dismiss the appeal for lack of jurisdiction or to affirm the trial court's order. This is a termination at the initial disposition. There hasn't been a disposition yet. Nothing is appealable by right at this juncture. But
I agree. You're correct. And you know, this isn't just to give you something to chew on, and maybe to run by the trial guy who probably doesn't know anything about this. But you know, it's one of those questions now that's come up. And that is, if it's not appealable by right, and if we don't catch it, which is what happened here, we didn't catch it. I mean the clerk's office. Can we have in the past said, well, we can decide these, we can, in the interests of judicial economy or for whatever reason, we can decide these cases. I'm not sure that that's correct. I don't know how a court can give itself jurisdiction.
agreed, Your Honor. Agreed. And yeah,
But
it's
we
definitely
do.
something we can
Talk about
discuss
later.
that,
Yeah,
yes.
right. So anyway, that issue is out there, but.
So unless there are any other, particular questions about the
Excellent
case.
brief. Thank you. Much better than the state, by the way, who filed 2 briefs this morning. So we do.
No
again,
comment.
I can't stress enough how much we appreciate your office, how, obviously we do our work, right? We try to read everything that's presented to us so that when you arrive, we can at least have well, these two can have a discussion. I never know what's going on. Just ask my wife. And if you don't file a brief until the day of, and it's very unfair to everybody in the case as well, because then you don't have an opportunity to respond. Anyway, I'm done. I'm off myself.
I just, one question, just to confirm for me, there's no case law or anything that lends any support to it seems to me that on appeal, respondent makes the argument. Look, I abused the half sister. That is my son's.
I didn't see any. In fact, the one
That's
case that
the
he.
theory in part, in one of the
Yes.
arguments, right?
Yes, and the case, as I pointed out in my brief, they cite 4 cases. 3 of them just stand for a general proposition, and one is factually distinguishable because the respondent parent, who was termination was being sought on, wasn't the one who was allegedly perpetrating the abuse. So I did not see anything else here.
Okay, thank you.
And that would sort of be a ridiculous outcome from our perspective. Would you not agree?
Concur, Your Honor.
But being new to the bench, I wasn't sure if anybody had been here to check Judge Barello in the past, so.
Thank you. Good to see you as
Thank you.
always,
Excellent to see you as
counsel.
well. Thank
Appreciate
you.
your assistance. That matter is submitted. Takes us to item number 7, case number 375-167 in Ray Owens minors. No one's checked in. Oh, I'm sorry. You are,
Matt Walton.
I don't have you down as having oral argument. Let me look at this sheet.
There's,
Does he? Okay, I apologize.
Well, I do, yeah, and it's on the second, number 7. There's 2 cases.
Oh, okay, got it. I apologize. Well, did you know that that the briefs were filed this morning in your case?
no,
Well, they were.
okay. Can I proceed?
Absolutely.
Again, I'm Matt Walton, and I'm here on behalf of Father Amanji Owens. He's the father of 2 daughters. I think they're 8 and 10 years old. This case is, the children allege that father hit them with a cord, mother hit them with a belt, so it's a physical abuse case. That's how it started. I have 3 arguments in that it was error to determine that DHS made reasonable efforts to preserve the family, that it was error to suspend parenting time, and that it was error to determine that it was in the best interest of the children to terminate the parents' rights. I guess importantly, there was a clinic done, and the clinic said that father suffered from depressive disorder, schizophrenia, PTSD, and anxiety, and that he would benefit from a psychological and psychiatric evaluation. The girls were waiting, I think, the whole case, years. They're on a waiting list for mental health services. They never did get it, as far as I know. Father testified. The court at some point at the best interest hearing said that father has done nothing. Father has a psychologist who is qualified. Her name is Lynn Smith. She testified that she's been his psychologist for years. That person was described by the government as a life coach or something. She testified as to her credentials. My client did do parenting classes, has housing, anger management class. He has a job, and so forth. So, firstly, I don't think the agency did much of anything. These girls were in 6 different foster homes. The 5th foster mother abused them and then was, I think, charged criminally, and her license was taken away. The 6th foster home, the foster mother didn't believe that the parents should have parenting time, so she refused to drive the kids. The new worker on the file, I think she was on for 3 months, then that became her job to deliver the kids to see their parents. So I don't really think
That occurred though, right? DHHS stepped in and the caseworker
that's correct.
did provide for the parenting time.
That's true. And at some point,
And were there issues? Am I correct that the records demonstrated that there were issues sometimes during the parenting time that required police intervention?
well, it's interesting. I think that's a January of incident that didn't get in front of the court until March. I'm sorry, 1 visit, 3/24. So I think the worker called 911. The police showed up, and nobody was arrested. Evidently, father mumbled, and it may have been praying, which I'm reading between the lines is a problem for the foster parent.
And they tried to redirect him, and then she testified she didn't want to redirect him because she didn't want to upset him. So after the court had ordered that a parenting time be, I'm sorry, they filed a motion that the AG, and after 7 visits viewed by the new worker, they terminated the parenting time. With respect to the best interest standard, this is kind of a general statement. It's not specific as to either child, but rather that it's just not in the best interest and so forth. So we believe a mistake has been made and that we'd ask that you reverse the lower court, send it back.
Any questions, counsel?
I think I understand the position from the briefs.
Thank you. Anything further?
No.
Thank you very much, sir. Those matters, and I should say 375-168, had I turned my page, I would have seen your name with the endorsement, are submitted. Thank you very much.
Have another.
Yep, go ahead.
Okay. Again, Matt Walton on behalf of the father in this case, his name is Londale Anderson. He is a father.
This is 375-168, right?
I have it at
There's this, I'm just trying to make sure.
375-682, but I may have.
I think you're skipping one of ours on the docket, counsel.
Sorry?
I think there's another case between yours.
Yeah,
On my list.
there's number 8. We have number 8 to call.
No,
before
he's got 2, but you're not endorsed on both, just so you know. Right?
Well,
So counsel, you just argued Inree Owens, correct?
Owens, yes.
Okay, and the case you were about to commence was Inree Anderson Ryan.
Correct.
Okay, that's.
Oh,
number
I'm so
9.
thank you.
We have number 8 that we still have to do.
Right, yeah.
That is
so-
not your case.
But just stay right where you are.
Okay. I'm
All
sorry,
right.
My bad.
Let me call it. Thank you.
And I'm
I
on 9.
understand now. Okay. Item number 8, case number 369-630, In Ray Grace minors. Again, Eva Trutz never comes. She's not here, hasn't checked in, right? Yeah, she never does. So that matter is submitted on briefs. Item number 9, case number 375-682, In Ray Anderson minors. Okay, sir, go ahead. I'm sorry.
Again, Matt Walton on behalf of the father and Angie Owens. Wait a minute, I just did that one, didn't I? Got my mixed up.
This
here.
is Anderson.
On behalf of Father Lonsdale Anderson, father of 4 children. This case started because there were twins and one of the twins died, evidently from malnourishment. I have 3 arguments that it was error. It was a violation of the 14th Amendment to take testimony after the no contest plea.
How is that even remotely an argument?
Well,
I have to be honest, I think that's kind of silly. Because the purpose of these proceedings is what's in the best interest of the children, right?
Yes.
The fact that this individual malnourished and allowed another child to die is highly relevant. That regardless of whether he agreed to it or not, no individual has the right to stop evidence from being introduced so long as it's material. And why wasn't this material evidence?
Well, I would agree, except for it was introduced at the best interest hearing. The amount of evidence that didn't happen at trial because of a no contest plea. And as you know, people make that argument for a variety of reasons. There might be civil liability or criminal case coming or whatnot. Part of the evidence so-called that came in was a worker who was not qualified to talk about malnourishment and so forth.
Well, that's a different argument than saying that allowing the evidence was a violation of your client's 14th Amendment. If you're going to say specifically this witness was unqualified, that's a totally separate argument, as I understand it, from saying none of this evidence should have come in.
Well, I guess my thinking is, Your Honor, that what comes in at that time, it's a 2-day best interest hearing, is whether or not it's in the best interest to return the kids home. Have the parents done their job? Did they work their parent agency agreement? Do they have a house? Can they maintain these children in a safe environment? And
You don't think that what's in the children's best interest would also include how a parent has treated their children in the past?
of course, yes.
So explain to me why this is a violation of constitutional rights then.
Well, I think that the statute provides the things that the court is going to look at, housing, whether they work their parent agency agreement, et cetera. This was a big deal brought up by the trial attorneys. And I felt like I had to deal with it.
So let me just clarify your argument. Your argument on the due process is based solely on the 14th Amendment, right?
Yes.
There's not a standalone Fifth Amendment argument, correct?
No, not that I make.
Okay, thank you.
So, in terms of opportunity to be heard, yes, they have an attorney, all of those things that go with the 14th Amendment. That argument was brought up at the lower court, the referee sustained the argument throughout the rest of the testimony in the second day of the best interest hearing. Second argument is that it was error to find it's in the best interest to terminate without making specific findings and specific findings as to each child. I don't think the court is supposed to just make a blanket statement that applies to all the children. And then lastly, that it was error to not to weigh that the children were placed with a relative and there was no need to terminate. I think the case law indicates that that's a factor that should be seriously considered. The court had also talked about a guardianship, and on several court hearings, a guardianship was never pursued. So we believe that those mistakes are sufficient enough to return this case and overturn the ruling.
Any other questions?
I don't think so. Not for me.
Thank you very much, counsel.
Thank you, Your Honor.
Matters are submitted. Thank you for coming. Appreciate your time and your submissions.
I appreciate that. Thank you very much.
Next is item number 10, consolidated cases 373677, 373679, 373708. In Ray Carter Waller, minors. No one has appeared. No one has been endorsed for oral argument. That matter is submitted on briefs. Item number 11, case number 374626, Ray Smith minor. No one's checked in on that matter. That matter will be submitted on briefs. Brings us to item number 12. Wow, there were a bunch of people endorsed on this one. Case number 375210, Warren Minor. No one's checked in. This matter was scheduled at 11. It's currently 1:04. Item number that matter is submitted. Item number 13, case number 375635, Ray Alsop minor. No one was endorsed. That matter is submitted on briefs. In item number 14, case number 374536, Solomon versus Wiggins. That matter is submitted on briefs. Okay. We are adjourned. Thank you.